May please, no, I beg to mention for listing on miscase for withdrawal.
When?
On Monday. Like,
Tuesday. Tomorrow it's a court.
May I please? I am praying for listing of two cases for motions on Monday. Lordship. We have filed long back, Lordship. It was in defective. Thereafter, we rectified it and then not listed.
Tuesday.
Lordship.
Tuesday.
Lordship.
A similar family.
When did you file?
2 days before my letter.
Okay.
Thank you.
Heard Mr. Ryan Ahmed, counsel appearing for the petition. Okay. Ms. K. Fukan is for the response number 1. Mr. Deepan is the department for the response number 7 and 4. Mr. P. Sharma, additional response number 3. And Mr. H. Puli. CI for response. This matter was heard earlier on 23/09/2024. It's fixed on 30/09 and it's fixed on 30/08 for necessary orders. However, concept for the made a mention yesterday for listing of this matter today for withdrawal of this. Mr. Ahmed, counsel for the petitioner subject that on instruction he raised for withdrawal of this.
Lordship, with liberty, the petitioner approached.
Matter was already heard.
Lordship, petitioner approached before the tribunal. He collected some documents,
That
filed a review, Lordship.
We have heard the matter, you should have said it.
The- Lordship, with liberty, Lordship, I approached before the
If he
tribunal.
wanted to bring in additional documents, you could have filed an additional affidavits. What is the necessity?
The Lordship,
No other way.
he before the tribunal, Lordship, filed a review, Lordship.
You want to file a review?
Review, Lordship.
You file a review, then you don't require.
The review
No
before,
liberty is necessary.
before the tribunal, Lordship. With liberty, Lordship.
Only.
Stating that the petitioner shall file a review before the
mention को आएगा, नौकरी करना चाहिए.
I wouldn't.
Mention that.
furnace terminal Berkeley. As petitions are dismissed on the registry set.
With liberty, Lordship. Filed.
Return the records of FT case number 654/2017. A copy of this order. The furnace terminal Udali.
Diplomas.
कॉपी में दीदी पारे ना मेरी मेल ईमेल दीदी पानी सर प्रिंट आउट में 3 टाइम आके चला सर मतलब first lordship 15/11/2014 prior to that मतलब there was another scheme, it was 24 April 2007. It is just after that मतलब. First 2 pages is the 2014, then the next one. 24th of April 2007. If Lordship is holding the notification of 24th April 2007, the Lordship will find serial number 1A, my lord. Existing quantum of relief, it was nil, then it was proposed pre-election rupees, my lord. And thereafter, my lord, another notification is there on 6th of December 2014. The manner in which, my lord, from who will pay, how it will be disbursed, it is clarified there, my lord. On 6th of December, Lordship will find after the 2004 notification, it is there, my lord.
Procedure.
That is the procedure. From who will do, my lord, how? It was. That's a copy file of middle.
Latest
Latest such as 5 lakhs. I got 3 lakhs. What is silent about?
Hello.
A2 details.
Five.
A2 details.
2014 or
Well, there is a subsequent clarification, although it is not relevant for this case, but there is a clarification. Well, I have given the copy. Well, the cases of motor accidents, except hit and run claims, those are excluded. This is not relevant for this case, but it is there. It is a this is a development, subsequent development. It would procedure. It is procedure. It would procedure. Not procedure. পিছত দিব লাগিব কেছটো হৈ লওক আপোনাৰ এটা কাম কৰক মোৰ হেৰিটো দিয়কচোন হোৱাটছআপ এটা মোক তাক কওকচোন হোৱাটছআপত মই এটা দিব মই পঠাই দি আছো ঠিক আছে মোৰ নম্বৰ আছে নেকি মোৰ নম্বৰ আছে 98641 এটা হোৱাটছআপ হাই এটা দিয়া মই পঠাই দি আছো 98641 056 আছে WhatsApp এটা দিয়া WhatsApp হাই এটা দিয়া
Mr. Na,
Malan.
last occasion, you have given us a copy of the communication of the Superintendent of Police Cognizance. Communicated to you, which you have placed before the. There's a communication of 9th of September 2022, Superintendent of Police. Do you have a copy of that?
Malan.
Do you have a copy of that particular communication?
Of 9th of September, Malan. Yes, yes, sir. There, Malan, for first paragraph, Malan, the last sentence.
Yes.
The second last sentence, my lord. They said that on receiving information, SI Hitendranath Roy, the then OC Kazigaon PS and ASI Sukumar Bhattacharya in charge Rupsi outpost with other armed police personnel reached the spot, and to manage the crowd, police started blank fire. In the said incident, Hayat Ali was severely injured with bullet and he was brought to civil hospital Dhubri, but he succumbed to death, and another 3 persons, namely Ranjit Das, second Ibrahim Sheikh and Tahirul Islam, also injured in the said firing, and medical assistance was provided to them. So, my lord, our case is that to manage the crowd, there was blank fire and he sustained injury, my lord.
What is a blank fire? What do you mean when you say blank fire?
My lord, normally, my
Are
lord,
you aware of that? What is the procedure? How it should be?
my lord,
Look at the postmortem report of the victim,
that's
where the injuries were. Blank fire is such that police personnel will be on their knees. They will take the firearm on their shoulder with a 45-degree, they will fire it. Look at the injury sustained.
not
So you can understand to what extent the victim might have jumped. Look at the injury.
I've seen. In the back of right abdomen, there is in the abdomen
So
there is.
to what extent he might have jumped to have that injury? That's because police personnel had a 45-degree wind in their shoulder and they have fired such a blank. You can understand what kind of blank fire it was. We're not denying the fact there might be some crowd because they wanted to burn down the car, or in fact they had already burned. There are unruly mobs are there.
What has happened in a spur of moment? It has happened. There is
No doubt, we are not denying.
true.
But if you read the search, as well as the report of the superintendent, there is no indication. His presence might be there. Anyone, curiosity, everyone will be there or anything will happen. But thing is, whether he was involved or not, there is no mention. Neither in this, in this particular Kazigaon case.
It's a part of that movement.
And
So the
one
part of-
injury is from the backside, just think.
Yes, yes.
One injury is from the backside. So a person having a bullet injury in stomach, in abdomen area, and the other injury from the back means what? Only when he'll be in the ground. Or maybe possible while he was running, he might have fallen down in that circumstances. Maybe he was the backside. Fell down in that may possible.
After police has come, they may have just run from this place. my lord.
And
In-
if you read how many rounds of firing was there in his
There is a movement.
Only one
More
clarification,
public
my lord,
people, no?
that we have, the people became unruly when police fired. Later on,
We do not know.
but my learned friend says that there is a
Mr.
custody were to come.
Mahmood, we do not know. Whether police, the public gathered there became unruly after police firing or because of some unruly police had to fire. We do not know at this stage. Okay.
As I answered to my learned friends.
Mr. Mahmood, learned counsel appearing for the petitioner. And Mr. Dinath, learned senior government advocate Assam for all the respondents all the official respondents number 1 to 7.
But
As we ask, Mr. Nath, learned senior advocate have placed all the relevant office memorandums and notifications
by name of
relating to compensation amount payable to the victims. During firing incident by security forces of 24/04/2007. 15/11/2014. 06/12/2014. 26/12/2014. 15/11. And 6 January 2015. As well as 31/10/2023. Other parties, other councils, the party applied, order reserved. Yes, next.
Let's suppose this was the man.
Full dispose.
I'm on.
The order.
I'm on.
They're not passing the order at least they will.
See, this matter may be taken after some time.
Also, be directed to personal appearance with all records matter. He is present today. Circle officer board ক্ষেত্রে matter. The next thing. That's all. Adios.
My lord,
Please wait. Certainly, let's go. Application. 21. 239. Long number. Hukum Muhammad menunggu takbir mati upah kalian telah Jasimuddin, Kasimuddin, Ramila, ini kalau putih putih sebelum already 8/2/13 third week of already in the mission. Put us.
That was no, 1997.
Mr. Sharma,
Lordships.
who is looking after this records?
Yes.
Land records?
In Majestic.
Who is he? Who is with you?
Circle officer. Borkhetri. Circle officer Borkhetri.
Okay. Please clarify certain things. Come to page number 106.
Lordships below. In 1997, my lord, that the Amdari was cancelled. Again, and
চক্ৰ বিষয়া মহোদয়ৰ 8-3-2013 ইংৰাজী তাৰিখৰ হুকুম মৰ্মে খ-দ সূত্ৰে ৰেহেনা ৰমিজ জহুৰুদ্দিন নীলচানৰ স্থলত 239 নম্বৰ দাগৰ 2 কঠা 8 লেচা জমিত নয়মুদ্দিন পিতা নয়ানন্দীৰ নামে নামজাৰি কৰা হয়
2018, not
18
2006.
চক্ৰ
Please, Mr. Sharma,
Lordships.
come to the top 106.
Yes, my lord.
চিঠাৰ উপপ্ৰতি সমাহৰ্তা মহোদয়ৰ 9/4/1974 তাৰিখৰ হুকুম মতে
Yes.
ৱাৰিছ সূত্ৰে
Waris.
ভানৰ
Uh,
স্থলত পাট্টাৰ সমুদায় জমিত এন্টায়াৰ লেণ্ড অফ দি পাট্টা
yes, Lordship.
ছবিৰন নেছা চমলা খাতুন মইনুদ্দিন নামজাৰি কৰা হয়
Yes.
Date is 23rd of March 1974.
70.
Now this is relating to the entire patta
Yes, entire.
minded.
Yes.
Now down below
Yes. Down below, my lord. 21, no, 96.
you will see again the next kho land four lessers of land of dag number 239 and 2 lessers of land of dag number 269 as made Sarkari, made government. Then there remain only out of 1 bigha 15 lectures, 4 lessers gone, 1 bigha 11 lessers for 239 and 2 lessers out of 1 means 1 bigha 3 katha 12 lessers,
12 lesson.
14 lessers. So then you'll come down again, you'll just see there are some sale and anything. Straight away come down to Jha.
Yes, ma'am.
BB, the Dolil number something because DAW it is there. I don't know what you mean by DAW. Z would have been in Gothor, miscellaneous case, but it is BB DAW number
96, 97.
21/96/97, right?
Yes, Lordship.
তাৰিখৰ হুকুম মতে 212, 239, 269 নম্বৰ দাগৰ উলম নামজাৰি হিচাপে 3 নম্বৰ পাট্টাদাৰৰ নাইমুদ্দিনৰ নাম ৰদ কৰি
Yes, Lordship.
চমলা খাতুন আৰু তৰিবন নেছাৰ নামত বাহাল ৰাখা হ'ল,
Bharal. Yes.
right?
Yes.
Then come to 107, Mojinio Top.
Yes, Lordship. So,
চিঠা দিয়া চক্ৰ বিষয়াৰ 10/8/2009 ইংৰাজী তাৰিখৰ হুকুম মতে উত্তৰাধিকাৰী দখল সূত্ৰে পট্টাদাৰ হাছমতৰ স্থলত পাট্টাৰ সমুদায় জমত The entire patta land
Entire.
now has now gone to Rehna Begum, wife of Hasmat Ali, Muhammad Ramiz Ali, Muhammad Manuruddin, right?
Yes, lordships.
Now, where from the name of, now come to,
Again, my lord,
Two.
next
then 1 years down below,
down below, my lord.
it's written O, first O,
Oh, my
zero,
lord.
right? চিঠাৰ চক্ৰবিষয় মহোদয়ৰ 8-3-2013 তাৰিখ ইংৰাজী তাৰিখৰ হুকুম মতে খৰিদ্দাৰ দখল সূত্ৰে পাবক ৰেহেনা ৰমিজ জহুৰুদ্দিন চিনাচলৰ স্থলত
Noimuddin.
ডাগৰ 2 কঠা 8 লেচা জমিত নন্দিনী নামত নামজেৰা কৰা হ'ল।
2013.
When it was such purchase was done,
He purchased them in 2013 and record was collected again 108 lordships.
hmm?
108 my lord. চক্ৰ বিষয়াৰ ইমান তাৰিখ 28/9/2018 নামজাৰি নম্বৰ
Then you come to second O,
Second, yes.
চিঠাৰ চক্ৰবিষয় মহোদয়ৰ 7-5-2013 ইংৰাজী হুকুম মতে খৰিদ্দাৰ দখল সূত্ৰে প্ৰৱগণৰ স্থলত 212 নম্বৰ 1 বিঘা 1 কঠা 40 জমিত মহম্মদ নয়মুদ্দিন নামে নামজাৰি কৰা হয়। Can you just see the next? বিবিধ দৰখাস্ত চক্ৰ বিষয়া সাচেন নামত 7-5-13 তাৰিখৰ হোৱা চিঠা নামজাৰি নাকচ কৰি পূৰ্বৰ পত্ৰদাৰৰ নামত বাহাল ৰখা হ'ল। Right?
Yes, lords.
Yeah.
Now,
My lord, may I point out one thing, my lord? Okay.
also was, where was the land available at 239?
My lord,
Because Hasmat Ali was already the particular owner of the entire land of the Patta. Prior to that, it was Samla Khatun and Sabiran Nisa.
my lord, may I point out one thing, my lord?
What is there in the record?
Report, my lord. He purchased the land in 2013, my lord. As per original record. There no, he purchased the land 2/5/2013. From and on the record, it was corrected in 2018, my lord. On the basis of that. पट्टादार खरीदार पुत्रे
এক বিঘা 1 কঠা 6 লেচা তো নয়মুদ্দিন 2013 চনত
Mm. 2013.
Now, at page 34. Page 34 of this petition, annexure 1A.
1A, Lordship.
Kindly read.
Statement of Mohammed Qasim Ali, son of Naimuddin, village number 3, Larkuchi, PS Mukalma, district Nalbari, Assam, age 25 years. My name is Mohammed Qasim Ali, son of Naimuddin, village number 3, Larkuchi, PS Mukalma, district Nalbari, Assam. My age is about 25 years. I belong to a Bengali Muslim community. My mother language is Bengali. I have been living in the aforesaid village for about 20 years. I do not have any plot of land of my own in this village. Presently, I am residing with my parents over a plot of government land. My original house was Faridpur district of Bangladesh. In my early life, my parents brought me in India through Dhubri district of Assam and started living in the aforesaid place. There is no any legal proof of Indian.
It was before police, right?
Yes, my lord.
It was police.
He stated all things. নিজে কইছে মাটি নাই বলে।
Annexure 1, B, C, and D, my lord.
কইছে। ডেটও মেম্বার ডেটটা থাকবে এতিয়া কইছে
Original sorry, police. তো আরো হয়নি।
পুলিশের আবার কইছে তো আমাদের কেন নাম্বার কইছে
ওটা করবো,
কাসিম আলীর নাম্বার তো পাওয়া নাই পরিষদ
Now tell us, when did the father of the petitioner purchase land?
2013 my lord
What
Seven
is the area of land? What is the Doug number, Pata number?
Related. Tag number minor 239, pattern number 150. Tag number 239, pattern number 157. No?
2 কথা 8 লেছা এইটো
239, tag number. Pattern number 157.
157
Fine.
Total length
After such sale, what was the total area left in Doug number 239? Have you ever calculated?
yes, 239 tag আছে তো এটা। Original record blocks is দুই কথা 8 লেসা।
2 কথা 8 লেছা
Original record plot is in 2013. It has mentioned that Faridar Kutre, Patadar or Manor Imote, Bilkota Atlesa, Native, Naimuddin Namdari Para.
No, what we want to know from you,
5
when the
2013.
petitioner's father purchased this land at Doug number 239,
As
what
per
is the
record,
total area of that Doug? Because prior to that, land was already sold to many persons, right?
many percent.
So what is the total area left?
Total
Because the circle officer,
3 kotha 7 lesa.
total amount of land in Doug number 239,
So after selling out, the land will left out, the quantum of land that will be left out will be 3 kotha 7 লেছা on 239 number Doug, sir.
total land out of 1 bigha 3 kotha 14 lesses, because 2 lesses has already become government land,
Yes,
right?
sir.
So out of 1 bigha 3 kotha 14 lesser, who are the persons to, what are the total area of land was sold by the owners of that land?
Total means no.
1 বিঘা 3 কথা 14 লেছা
Video. Total land was minor
1 বিঘা 15 লেছা
1 bigha 15
15
lesa.
lesa.
Total land.
Now, in this particular Jamabondi, is there anything on record after deleting the name of the father of the petitioner?
Naimuddin.
Naimuddin, right?
Three kotha
From Doug number
2 কথা 8
212,
212.
was his name again corrected in the Jamabondi land records? Because earlier you have read his name was deleted,
Yes, sir.
right? His name was deleted
Deleted.
from
1997.
212.
212.
You have,
19
you are aware, right?
1997, man.
That you have read Jha. First was Jha in the first page 106. Then at small o at the last part of the 107.
Yes, sir. Yes, sir.
Right?
Yes,
On 3/11/2014,
yes.
it was cancelled.
It is cancelled.
Now thereafter, any order was passed with regard to Doug number 212 in favor of the father of the petitioner as per the Jamabondi.
Naimuddin. চক্ৰ বিষয়া মহোদয়ৰ
Which one? Which one?
One
On
zero
which
seven.
date? Serial number?
107. Seat here, 107 lordships.
Huh,
Is reading.
huh. Yes,
চক্ৰ বিষয়া মহোদয়ৰ ৭-৫-১৩ ইংৰাজী তাৰিখৰ হুকুম মৰ্মে খ-দ সূত্ৰে স্থলত ২১২ নম্বৰ দাগৰ ১ বিঘা ১ কঠা ৬ লেচা জমিত মহম্মদ নয়মুদ্দিন পিতা নয়ানন্দীৰ নামে নামজাৰি হয়।
Then read the next column.
Next one.
এইটো নেকি?
কৰক।
772/3/11/014 নং বিবিধ দৰখাস্তৰ চক্ৰ বিষয়াৰ মহোদয়ৰ ৩-11-14 ইংৰাজী তাৰিখৰ হুকুম মতে ৭-৫-১৩ ইং তাৰিখে হোৱা চিঠা নামজাৰি নাকচ কৰি পূৰ্বৰ পট্টাদাৰৰ নামত পট্টা বাহাল ৰখা হয়।
So was there any land, that number 212 in favor of Naimuddin?
No, neither.
No, sir, no.
You are clear?
Yes, sir.
So there was no land
No land.
in the name of Naimuddin at Dag number 212
Yes.
of this particular patta.
Yes.
Mr. Sharma, you have heard?
Yes.
Explained by the circle officer.
আমার নাই তো। নাই তো, করতে না।
Please come to page number 121, Mr. Sharma, and read para 25.
121. 25 verses. That there is a landed property in the name of Naimuddin, son of Naindi, the father of the opposite party, height KP Pata number 157, dark number 212, measuring 1 biga, 1 kattha, 6 lesa, which is duly mutated in the name of Naimuddin. A photocopy of your certified copy of the Jamanmandi is enclosed.
Is it correct
Not to be seen.
as per the land records?
Lordships.
You have seen that his name that was incorporated in Dag number 212 was deleted, cancelled,
Yes.
right? Just now the circle officer from verifying when the records have said it so. Page number 107.
Lordships, I am seeing the original records. Neither.
No
No, no, right. There is no limit.
land.
Whether his name was re-entered or corrected after deleting his name, cancelling his patta in
No.
212.
No, no.
Tell us.
Something go.
No,
We are
sir.
verifying from the records.
Yes, sir.
Okay.
As per record, 2013, he purchased that land.
Then what happened? It was cancelled.
Yes.
It was cancelled, right? Thank you. Now tell us if somebody misrepresents before the tribunal or court, what to do? Yes, you can ask the circle officer and his colleague to take it. Tell us. If somebody misrepresents before the tribunal and court, what to do?
I live in Lordships, what about? Because Maharaj, he is misleading the court.
Tell us what to do. You are representing the Banki government.
2018, 2018 also. 2018 তারপর তোমার ক্যান্সার আছে
সার্কুল অফিসার নাম নাকি আর কোন
মাটিটো কিনিলে এইটোত আকৌ সিহঁতে কেঞ্চেল কৰিলে
অফিচাৰে
সেইকাৰণে কৰিছে যদি এইটোত কেনেকৈ যদি কেঞ্চেল কৰে তেতিয়াহ'লে আকৌ কেনেকৈ সেইকাৰণে বুলি কৈছে এইটো ক'ৰ্টত কি কৰিব
Tell us.
I leave your lordships, my lord. That is actually wrong, my lord. I leave your lordships, but leave your lordships.
What? You have to tell us what to do. What happens when somebody misrepresents before the court or the Constitutional Tribunal?
So বিষয়ের প্রেস নামক
কাগজ।
এটা কি কোন কোয়া
ID খনৰ কপি কাগজ লাগিবতো অফিচিয়েলি আহিছে ন
জাতীয় দিছে তুমি
Heard Mr. Imanaf, counsel appearing for the petitioner.
My lord, may I point out?
Anyone representing the Union of India? No representation on behalf of the Union of India. Rest for number one. Heard Mr. J. Payang, Standing Counsel, Home Department, Assam, for the response number 2 and 3. Mr. P. Sharma, Additional Senior Government Advocate, Assam, for the response number 4. And Mr. H. Cooley, Standing Counsel, ECI, for the response number 5. Pursuant to our earlier order, the present circle officer of Borkhetri Revenue Circle, namely Kaustubh Roy, son of Sarat Chandra Roy, personally present with the original records of Jamabundi relating to land of KP pattern number 157. Consisting of Doug numbers 212, 239, and 269. Of village 3 number Larkusi, comma, lot number 2, West Borkhetri of Borkhetri Revenue Circle of District Nalbari. From the records in origin. The concerned circle officer present before the court clarified that pursuant to the order of the circle officer dated 07/05/2013, name of Naimuddin, Muhammad Naimuddin, son of late Nayanandi, was incorporated for a land measuring 1 bigha, 1 kata 6 acres at Dag number 212 of said patta number such and such. On the basis of purchase and occupation. However, on the basis of miscellaneous application number 772-3/11/014, on the basis of liquor, order dated 03/11/2014 passed by learned circle officer in application number such and such and such. The registration name of said Naimuddin, son of late Nayanandi, was deleted / cancelled from the land records relating to said land measuring such and such and such, the number such and such, in terms of earlier number such and such. And re-recorded the names of the earlier pattadas. And accordingly, the records relating to patta number 157, Dag number 212 was corrected. It is to be noted herein that the petitioner in his written statement submitted before the Foreigners Tribunal Nalbari 3 in FT case number within bracket NAL-3 bracket close 13/2021. That was initiated against him, submitted at para 25, something, that his father, Naimuddin, son of Nandi, had landed property over KP pattern number 157, Dag number 212, measuring 1 bigha, 1 kata 6 lesser. That was duly mutated in the name of Naimuddin, within bracket, his projected father. It's a notice returnable by 6 weeks as such and such and such. No formal notice need to be issued. Petitioner shall serve requisite extra copies of this petition will be in excess on or before such and such to such and such. 1st of October, obtaining necessary acknowledgement in that period. Petitioner shall take steps for service of notice on the respondent number. Petitioner shall also serve a copy of this written to Mr. R.K. Dev Choudhury and additional solicitor and such for a walking for the respondent number 1 on or before Friday. Petitioner shall take steps for service of notice on the respondent number 6 by registered post OTD on or before such and such. Call for the records of FT Udin Beckett NL 3 case number 13/2021 from the office of the London Foreigners Tribunal number 3 Nalbari. And leave this matter for immediate admission immediately on receipt of the said record. Personal appearance of the circle officer of Borkhetri Revenue Circle, namely such and such. Stands dispensed.
Record my lord.
And the records placed before the court be returned to him.
My lord, he may be protected fine. He may be protected fine.
Will consider in the interim period of the petitioner shall be considered
In record number, I will be
renewal of the records in original. FT record, correct.
written will be sent.
Obliged.
Where is your link document?
My lord,
Your link document.
linkage document,
Yes.
page number 39, my lord.
Yes.
This is the 1997 voter list,
39.
page number 39.
Is it a certified copy?
It was annexed. It is not a
Have you
certified
proved
because the petitioner was marked a D voter. So in his name, my lord, the certificate cannot be issued. That's some rule of the election office.
Are you sure?
Apparently, they are not given issue. I have never seen.
If a person is declared a zero, then a certified copy is not issued. Within this instruction.
Kindly come to page number 49,
49.
or you can read 50. Straight away.
49 or 50 million?
50, 50.
50 million.
This is the cross of the proceeding.
My lord,
Please read.
I have not mentioned the year of birth in the written statement. Nawaz Ali is my father. He has no brothers and sister. Alam Sheikh is my grandfather. Has no brothers and sister, and only son Nawaz Ali. Nawaz Ali has 7 number of sons: Abdul Salam, Haider Ali, Abdul Qadir, Abdul Jalil, Abdul Kareem, Prosidi, Rahim Ali, Abdul Rahman, and 4 numbers of daughters: Zahira Khatun, Rahima Khatun, Amina Khatun, Mumtaz Begum. Amongst them, Rahima and Zahura Khatun and Abdul Rahman are expired. Their names are mentioned in the written statement and affidavit. My father expired in the year 1993. I have not submitted Jamabandi copy of land documents in the name of my father. I have got, I have not submitted the mutation order in the names and other legal heirs. I have not submitted any linkage certificate in the written statement and affidavit. Exhibit D certificate Gavura is submitted as linkage. Question put by the tribunal and reply recorded authority by. I have not mentioned the patta number and dag number and the position of the land certificate.
So which was the linkage document?
Milord, the Gavura certificate is another linkage document, Milord, which I could not annex because it was not with me, but it will be in the LCR, Milord. But the son of the Gavura appeared before the learned tribunal because he was sick. And he said that this is his father's signature, which is Milord DW4, page number 67. He's the son of Gavura Uddhav Musari.
I thought this was on today now.
Yes, Ms. Verma. Please come to page number 20.
Yes,
Date of the order.
31/10/2018, Lordship.
Now please come to page number 16. Read para 24. Can you read? It has something here sometimes.
Lordship.
No
You've
explanation.
written several letters.
No,
Now,
not explanation.
I
Right?
have,
How can you, unless you are instructed?
no, Lordship, this is not there. I have, last time in
And,
this bench was in
And for your information, the petitioner filed this petition on 12th of August 2024.
24, Lordship. Lordship, we have some input from the police whenever, they go, Lordship, in the evening rounds to look for these proceedings, they are most of the time missing. In fact, we have now started seeking for the logbook when they go to, when they go to search for them to arrest them, Lordship. In my next, instructions, Lordship, I will be producing the logbooks. They are never available. It's the same thing like when they go to serve the notice, they are not there, and when they go to arrest them also, they are not there.
Would you like to go to the records?
Yes, Lordship.
That, when the record, you pick up the matter after vacations,
Yes, Lord.
but no interim.
My humble sub.
No, because see, 2018 matter, you are coming in 24.
My lord.
What is your explanation?
My lord,
Only
para,
because he could not get her money.
para 23, my lord.
We have seen that. When you have seen 24, we have also seen 23, right?
My lord. I am being very transparent. I have mentioned everything, my lord.
I mentioned everything. I mean, we protected in the meantime, my lord. Otherwise, it's a
Lordship is
good case. my
already
lord.
protected because they're never in
No,
the
now-
residence,
now-
Lordship.
2018, the order was passed.
My lord, my lord. I bow down to your lordship. I completely
6
agree.
years.
My lord.
You're protected.
My lord, now the police is bothering me.
Since
the police-
August and Lordship, when he filed in August until date, he's not been found. Now, Lordship, what we have said, we have written to the Home Department that when we seek instructions why they have not been arrested, we would like to have the logbook with us, Lordship, to place it before this court. How many times the police has visited and not being able to trace the proceedings, Lordship.
There must be proper explanation.
My lord, like may I take your lordship through page 21, my lord? This Gavura certificate has been rejected without giving any reason. Even
Because the person is not there, the Ambura was never examined.
my lord, may I please read page number 21, para 6, my lord?
Yes.
Page number 21, para 6. He says, in regards of the DW4, the Gavura could not appear due to serious ailing. His son was produced and identified the signature of the father of the Gavura as Exhibit D. Now, there is no reason, my lord.
And,
What reason? This
and how is
document
the
has-
certificate proved, Lordship? We can face it before this court.
Content of the document, we have to be through.
And look, there were 4 voter lists submitted. Voter list of 1997, 2008, 2010, 2007, Milan. Now, what happens? I have been marked as D. The authorities do not give me certified copy. Now, my hub battle is lost there. Had I not been a D voter, I could have exhibited this document. This is annexed, but not exhibited. Lord, I lost my linkage. Because they are not giving me that. First of all, you declare me a D voter and then you don't give me certified copy. My half battle is lost there.
Where
my
is the reference? Where is the reference?
lord. Reference, I don't have a copy in the LCR, my lord. And I'm sure entire reference would be blank, my lord.
Examine. Nobody will schedule it. वो घर में भाग कैसे भागा है तो मुझे नहीं पता। इसीलिए तो हम लोग के लिए प्रॉब्लम है ना, वी आर बीइंग विक्टिम।
उसके लिए भी तो प्रॉब्लम है, घर में नहीं पा रहे, आप लोग परेशान
वी आर विक्टिम्स बिकॉज ऑफ यू। एक बार अरेस्ट होके बेल ले लेते हो गया, नहीं अरेस्ट नहीं होगा। इनको भी लिखा है कि राम बोले का प्रॉक्सी आके एविडेंस देने से ना सारे पिटीशन में कितने फेक डॉक्यूमेंट निकाल देंगे वो नहीं बोलते क्या हम लोग हाईकोर्ट में बैठे हैं एसेंशियली में तुम्हारे लिए भी हमारे लिए भी तो हम लोग improve नहीं करेंगे। हम लोग improve नहीं करेंगे। Yeah.
Your definition was agricultural was considered with council representative. But neither you can interview. You did not cross. You did not cross. How do you know? How do you know?
Yes, you can go through the records, we'll take it up after vacation.
I will be protected.
Or we'll only say that you will not be deported in the meantime.
My lord, deportation will anyway. I generally don't insist so much, my lord. This person is extremely poor, my lord. Humble submission. I will be protected, my lord. Till next date, my lord. Till next date.
You'll be taken well, you'll be well taken care of in the detention center.
Or till next date, my lord. Till next date. Respectful submission, my lord. My lord, this order is so bad, my lord. My lord, I have mentioned.
You point out some infirmity in the order to say that, no, this part has never been considered, or this was not, nothing was appreciated. Something to say,
My
what
lord,
is the basis for giving you an interim protection after 6 years?
my lord, because I have annexed the document, I have proved the linkage. There is a
How?
Gabura certificate, but the state is not questioning the authenticity of the certificate, my lord. He should have. I should have.
State need not. This section itself says it is, the burden is on you.
My lord.
Now your burden is not exhausted by merely filing the document.
My lord, the
You
burden is on
the
me.
contents of the document.
I submitted 4 voter lists, my lord. I have mentioned in my written statement there was no investigation before marking me as a
You could
D-voter.
have filed an application for summoning the officials of the election department.
My lord, the burden is on me. First of all, I have been marked as a D-voter without any investigation. I have mentioned that in the written statement in my para 2, my lord. And then they mark me as a D-voter. Then they don't give me certificate. My entire linkage is gone, my lord. My entire linkage is gone.
If you are marked as D-voter, you have remedies
My
to
lord.
challenge such an action.
But my lord, that burden is again harsh on me, my lord. That burden is, why are they not giving me certified copies, my lord? Had I been given, my lord, I would have proved very easily.
Certified copies is all right, but you have managed to enclose some of the documents.
My lord, the brother also appeared, my lord. The neighbor also appeared, my lord. Section 50 of the Evidence Act, my lord. I may be protected at this state till next date, my lord. My last humble submission, my lord. Till next date, my lord.
The Gavpura certificate law. There is no law to say that the Gavpura can have a proxy witness before the tribunal lordship. And how it has to be proved, it is very clear in Vipajan Devam. That such a certificate of our Panchayat secretary is by no means proof of citizenship.
You are not convinced, Mr. Please understand.
My lord, I bow down before your lordship. I have submitted wisdom of your lordship to
Submitted,
protect
we
your
have
lord.
considered, we have not rejected it.
My lord, my lord.
We will reconsider it after reopening. Let them
My lord.
examine the records.
My lord.
Meanwhile, you shall not be deported. That much of protection we can give.
My lord, I'm grateful. my lord.
Pursuant to the earlier order dated 11/9. The FD tribunal records in connection with FD case number so and so has been called for and same appears before the court. We permit the counsel to the Home Department to examine the go through the tribunal report and apprise the court on the next stage. Let the matter be listed immediately after reopening on a date fixed by the registry. The prayer for interim will be considered on the next stage. Meanwhile, without further leave of the court, petitioner shall not be ordered out of the country in pursuance to the opinion dated so and so, passed by so and so tribunal.
Mobilizing.
List report.
Opinion details date
You may
31
examine the records today or
2018.
before the next date.
Foreigners Tribunal Military Corporate in FT case number 40 within bracket Roman 3 of 017.
Grateful.
Come here, Lordship. Expiry order, my lord. A petitioner filed written statement as well as evidence in CP, my lord.
Then how come it is expert?
My lord, page
What kind
74.
of expertise?
My lord subsequently could not appear.
Expertise because of non-appearance of the proceeding or expertise
No,
because
my
of the
lord,
non-service of
and
notice
my
property?
lord, in the meantime, advocate of engaged counsel, my lord, withdrawn his wakalatnama, my lord. Which is
Why?
a petitioner could not provide the adequate fee to the learned counsel, and as such, my lord, he has withdrawn his wakalatnama, my lord. Page 74, my lord, kindly. Page 75, paragraph,
How many occasions
my lord.
your counsel took time on your behalf before the tribunal?
Here, my lord, page 75, my
Tell
lord.
us how many occasions?
Order sheet is not with me, my lord.
Reflected in the order itself, page
Here is-
75.
Page 75, first paragraph.
One month before this infringement opinion was passed, that is at page 75. Not much earlier, that have been submitted. Just 1 month before that. Page 75, the first paragraph. Thereafter, several opportunities are granted on the pair of Mr. S. Islam, learned counsel appearing for the OP. Finally, on 2023. The council filed petition making a prayer to allow him to withdraw the wakalatnama as the OP has not shown any interest in participating in the proceeding, and accordingly allowing the prayer of the learned council, matter was fixed for ex parte order to be delivered on 10/4. If the petitioner himself is not interested in proving his citizenship and cooperating lordship.
1964 order.
Yes, my lord.
You have which you know.
Book.
Read order 3. Sorry, rule 3, sub rule 5. Not 5, straight away come to rule 3, sub rule 8. Kindly read. Rule 3, sub-rule 8.
Yes.
Kindly read.
And the foreigners tribunal shall give the proceeding a 10 days time to give reply to the show cause notice and further 10 days time to proceed evidence in support of his or her case.
Then 9,
9. The foreigners tribunal may refuse a prayer for the examination of the witness on commission for production of the documents if, in the opinion of the foreigners tribunal, such prayer is made to delay the proceedings.
10,
A foreigners tribunal shall take such evidence as may be produced by the concerned superintendent of police. The foreigners tribunal shall hear such person as in his opinion are required to be heard. The foreigners tribunal may be. There is the procedure for disposal.
so recorded in writing.
Yes.
Where is that rule? So he has
Yes,
granted.
my lord, I am stating in para 7 of my petition, my lord. A 70 years old man.
Lordship, if Lordship will see is the reference is of 2008, Lordship.
You have seen
We are
that.
in 24 today. Oh, yes. Required, Lordship.
I am DT case. I am DT case. I am DT case. That is the I am DT case has subsequently issue notice, my lord. Issue notice 21 or 21 of notice.
2018 में था,
Hmm.
2018 of register से 2021 in notice.
Hmm. Seven and 8 of my petition. One charge may be given to adduce evidence, my lord, and cross examination, my lord. He has the linkage, my lord. He has a linkage, my lord. He has sufficient documents also, my lord. His school certificate is here, my lord. His school certificate and land jamabundi inherited property, my lord.
You read the order first.
Yes. My lord. And my lord, due to poverty, my lord, he has not provided the advocate fee, my lord. And old as a
Legal
person,
is
my lord.
available.
My lord.
There's sufficient investment made towards legal aid.
It is a layman person, my lord. Actually.
You read page 75.
Hmm.
Second paragraph towards the end.
Upon receipt of the reference.
Thereafter, several opportunities. Page 75.
Yes. Thereafter, several opportunities were granted on the prayer of S. Islam Learned Council appearing for OP finally so and so. The council filed petition making prayer and allowed him to withdraw the Okalatnama as OP has not shown any interest. I mean, the tribunal has power to.
Read.
Yes. Achha, not shown any interest in participating in the proceeding and accordingly allowing the prayer of the Learned Council matter was fixed for expertise to be delivered on 10/4/2024.
Matter was fixed for ex parte order.
Yes. And
So.
delivered on 10/4/2023.
So therefore, you will first have to file an application for setting aside that ex parte order.
Then my lord, I may be allowed to liberty.
Who's stopping you? Go and file. Go and file a review.
At that part may be condoned if the file my lord review petition already
Let us-
year
let us go
gone,
through
my
the
lord.
Let
That's
us
why,
see
my lord.
from the record what comes. up.
At
So
that
it is not a case that it was suddenly taken up and decided ex parte. There was an order passed that in view of the absence, matter is fixed for proceeding ex parte. If you are a little diligent, then you could have filed an application for setting aside.
only my lord on the ground of delay, my lord, as such approach this honorable court, my lord. Otherwise, my lord, petitioner may file the review petition, my lord. But there is already 1 year gone, my lord. That's why, my lord. And delay part may be continued if the file a review petition before the court, learned court belonging.
Let us see the records first. Let us call for.
Yes, then, my lord, in the meantime, some protection, my lord, 70 years old
We'll
person.
give you some protection.
Yes, my lord.
Heard.
Yeah,
And
my lord.
accounting for the parties. Petitioner is aggrieved by the opinion taken. Ten four 2023 passed in FT case number 1765 of 2018 by the learned member Foreigners Tribunal, Bozali. Sub. Stopped by the state opinion. The reference made by the state after Foreigners Act 1946 against the writ petition was answered in affirmative and against the petitioner, and the petitioner was declared to be a foreigner of post 2503/1971 under section 2 within bracket small a, the Foreigners Act 1946, who had illegally entered into the territory of India within bracket Assam from the specified territory without any valid documents. Stop. Being agreed, present writ petition has been filed, praying for appropriate state directive. So, before proceeding further in the matter, this court would like to examine the reports, tribunal reports. So, the registry is directed for requisition. The tribunal reports pertaining to ethnic case number 1765 of 2018 from the Foreigners Tribunal for that matter be listed immediately after the examination. See the tribunal reports. In the meantime, the petitioner shall not be deported out of the country.
Shall not be arrested and deported.
Further prayer for interdict will be considered upon examination of the.
I may not be arrested, my lord. In the meantime, may not be arrested. But that part, my lord. Otherwise, my lord, 70 years old person, my lord. Some
70
protection.
years
my lord.
old. How
The
old is
police
he?
is run after him.
Huh?
Police is run after him.
Police will run only if he starts running.
Yes, sir.
At 70 years, if he
You
can
know,
run.
70 and years, 70 years, my lord, here. Only some protection, my lord. May not be arrested, my lord. Their part. my lord.
Okay, calling the next statement, let the LCR come out.
Let us.
No, LCR may come. I know, my lord, LCR may come, my lord. And may not be arrested in the meantime.
Officer already.
It is the.
We'll examine it. It's an ex parte order.
Yes, my lord, yes, my lord. Admittedly, my lord, 70 years old as a person, my lord.
70 years old.
So many diseases attracted the petitioner, my lord.
Next to Diana.
No, but you'll have
Abdul
to point
Razak.
out some error in the order.
No, there is no
We
error,
must
my
be,
lord.
we must be.
On the part of the petitioner due to poverty, my lord. He is a very poor person, my lord. He is a very poor person. He has collected, he earned some money with the help of one mission master, my lord. I am asking in paragraph 8, my lord. He has come, my lord, mission
He
master.
collected money for you.
No. He has some only just to filing expenditure, my lord.
We'll
And may
consider-
not be arrested, my lord.
Consider your prayer for it. Other it. Be considered. Upon, let the matter be listed immediately after you. Immediately. Upon receipt of the.
And may not be arrested, that part, my lord. Only.
We have given you some protection. And it may-
May not be deported means, my lord, police may arrest, my lord.
To
Put in the
Come and
detention.
take bail again.
That
Then
part,
file
my
an
lord.
application.
Only one sentence may put in the order, my lord. Old as a person, my lord, 70 years, my lord. Yeah, I have seen one
As
photo, my
a
lord.
counsel, you are to argue a matter, not bargain.
And for the interest of my client, my lord. He is a old person, that's why he is a poor person, my lord. That's why,
Next
my lord.
item called.
Oblige.
May please hold that. Lordship, the contesting matter of improved opinion is based.
Be little louder, Mr. Hassan.
My lord,
Be little louder.
my lord, is a contesting case, my lord, improved opinion is.
Your
based
microphone is
69.
on.
Page
It's on,
69.
Lordship.
Is it covered by some papers or what?
No separate. Get us. काम कराना नहीं है. Not functioning, my lord.
No, no,
Not
functioning.
functioning, okay.
You're a young man, you should be loud.
My lord, it is a contesting case, my lord. My lord, improved opinion is page 69.
We permit you to be as loud as possible.
Not, I think my friend, it is not functioning, my lord. Properly. Yes.
No, not through the microphone. Naturally, you can be as loud as you want.
Yes, yes.
Yes.
Where is the link document to?
In Dungan, my lord, father of the petitioner name has been appeared in the voter list of 1971, and the father has came and deposed. He is my son, my lord. And
Which
from
voter
the
list?
voter list of
Which
1990,
voter list?
voter list, my lord, page 29, my lord. Amsar Ali. My father deposition means, my lord, page 17, page annexure 17, page 63.
Where is the link to?
Linked document, my lord, the petitioner name and petitioner father name appeared in the voter list from the year of 1997 up to date, my lord. From the voter list of 1997, my lord, page 37, in certified copy, my lord. Amsharil is the father and Regina Khatun, mother of the petitioner, and Anwara Khatun is the wife of the petitioner. Due to demark, my lord, petitioner name was not enrolled, my lord. Come to the next page, my lord. Same voter list, my lord. A Rajak, demark is there, my lord. Then after the voter list is there, but due to demark, his name is not found in the certified copy.
Was marked D in 2008,
1997 for us.
97.
Last time. 39 number plus 7.
Is there any particular document you'd like to rely on? Show your link.
My lord, the link, my lord, brutalist of 1997. Then after uploaded brutalist, then my lord. Then after my lord, father has come and deposed his my son, my lord. Kindly come to the page, my lord, page 63, father deposition.
Then how is the father? How have you projected your father? How have you projected your father?
Father name is appearing in the brutalist of 1971.
Please come to the exhibit one, annexure 1, 66. Totally.
Yes,
Name of your grandmother. appears.
grandmother, my grandfather expired before 1966, my lord.
All right. Then
Then my lord, my grandmother name is there, 1966.
then you come to 70.
Yes. 71, my lord.
71.
Brutalist of 1971 and page, my lord, 29, my lord. Father of the petitioner name, Ansar Ali, and grandfather name is Noor Kamar.
Kamal. Said Kamal.
Noor Kamal.
No, if it is Nur Kamal, then who's Nur Kamal?
Noor Kamar is the grandfather of the petitioner.
Grandfather
Grandfather.
means he is the father of Amsar Ali.
He is the father of Ansar Ali.
The father of Amsar Ali.
Yes.
And who is the mother of Amsar Ali?
Mother of Ansar Ali, my lord, please, list of 1966, Kulujan Bibi.
Kulijan Bibi. And who is the husband of Kulijan Bibi?
Kulujan Bibi, the husband is Noor Kamar.
Nur Kamal.
Yes.
So the grandfather is Nur Kamal.
Yes.
And the voter list at page 30 shows
So Noor
Kamal.
is Kamal, my lord. Noor Kamar and Kamal.
Different village.
Village different, my lord. Different village, my lord. Village,
Then
village is
then come to
Mini Shimla and Cholchalia. The Mini Shimla and Cholchalia is the adjacent village.
adjacent.
Adjacent village, my lord, in the all other is same, my lord.
Then come to
Moja,
page-
Rupsi,
Then come to page 30. Which one is your grandmother?
Kulujan.
Grandmother?
Yes.
See the name of the
Yes, Sadek.
Sadek.
The list will be written, my lord.
Mistake.
Voter list are prepared by the election officer, my lord. But the village is same, my lord. Moja is same, district is same, sub-division is same.
Then 36. Then become Guru.
No.
So therefore, there are a lot of discrepancies.
Nuru, Noor, Kamar, Kamal. That discrimination is there, but other আছে মৌজা রূপসী মহকুমা বরপেটা সদর
In your WS, you are shown to be born in Salsolia,
চলচলিয়া yes
but in 66-71,
71 is চলচলিয়া
66,
66 is my lord
7,
uh,
it is many similar.
mini simla 66 is mini simla and 71 is চলচলিয়া but adjacent village
70 is also many similar.
70 also mini simla there is other voter list but I am shifting my lord only my single voter list is চলচলিয়া
So in your WS.
70 and 71 my lord.
Have you clarified anything in the
No, that is
WS?
not clarified in the WS my lord.
Huh?
Regarding the shifting, nothing was mentioned in the WS.
Nothing.
In the WS.
Let us examine the records.
My lord,
Current council for the parties.
in the member number,
They read by the order. Taken. 21/5/24. Fasting. PPT 11, PPT/11. FT 207/2017 by the Foreigners Tribunal Assam, Orpeda 11. The reference made by the state under the Foreigners Act 1946 was answered by the tribunal. Affirmative in favor of the state and against the proceeding from the tribunal. Combined that the proceeding could not discharge the burden of proving that he is eligible to be deemed citizens of India under Section 6, capital A, in the bracket 2 and 3 of the Citizenship Act, or that he was born in Assam or India during the relevant period. Stop. Being agreed, the present for proceeding further, we would like to examine the tribunal reports of the registry, acquisition of the tribunal reports containing case number so and so from so and so tribunal. So, matter be listed after the ensuing vacations on a date to be fixed by the registry. Meanwhile, without leave of the court, which shall not be reported. Prayer for injury be considered upon eligible. After reopening.
obliged. Okay, father has come, my lord, father is the existing voter in the, from the year of 1971,
Where?
this matter.
Item number 6.
No, my lord, item number 5, my lord. My lord,
We'll hear you after you.
obliged.
May please, Your Lordship. My lord, here in this case, my lord, the petitioner has challenged the order dated 6/9/2024 at page 59. It's an interlocutory order. My lord, the petitioner's grievance is twofold, my lord. First is, my lord, his prayer, her prayer for issuing someone to the election officer for authentication of the voter list has been rejected. Secondly, my lord, the evidence has been closed. He is to examine the Gaura and to prove the school certificate of her father. Father is not voter in 66, but grandparents is in 66 voter list. So in linkage of father is required by examining the school certificate. My lord, the evidence has been closed and case has been fixed for argument. My lord, the here date is 12/9/2024, but it was further adjourned to
22nd of October. My lord.
And what is the order in page number 48?
Page number 48, my lord, here, my lord, the same tribunal has decided many cases declaring foreigners for want of authentication of the voter list, my lord. Kindly have a look at, my lord, the summary portion of that judgment, my lord, at page 54, paragraph 5 and 7. The same tribunal is, my lord, declaring foreigners not accepting the evidence for want of authentication of voter list. So therefore, my lord, the petitioner is also apprehending that for the same reasons, he may be also be declared foreigners.
On apprehension, they are coming, ma'am.
Necessarily, it's
So your prayer has been rejected. Page number 59.
yes, my lord. And he is to examine the Gavura evidence as includes.
Let us call for the record that.
Yes, ma'am.
Well,
Because
Only call for calculation.
Which is a link document.
my lord, link documents, my lord, father's link documents with grandfather is the school certificate. That has been annexed as annexer 10. my lord. Father is not voter in 66-70. Father is voter, my lord, in 55. Grandparents is voter in 66-70. And link documents, my lord, Gavura certificate also of the petitioner.
my lord, page 59, the order says, my lord, the authenticity is not doubted. My learned friend is asking pressing some other judgment.
My lord.
The learned court itself says authenticity of these documents are not doubted. They are trying to delay the process. What is the necessity of this matter?
No, my lord. The
the
tribunal, there are so
tribunal-
many judgments.
No, on what basis he is saying? In their case, it is said, my lord, authenticity is not doubted.
But
On that ground, it is. So
for
what
want
is the
of
necessity of
authenticity.
calling the, my lord, that witness? If the authenticity is not doubted.
For authenticity of
They can rely this
documents
order later stage.
rejected so many cases.
They can rely this order in the later stage in the
No, my
What is the necessity of
tribunal
calling?
always,
This is
my
not-
lord, making.
They are trying to delay the process only, nothing
My lord,
more than that. My lord.
What is the cost, prejudicial cost to the
No,
state,
no.
my lord? If I,
No,
my
no, I am
lord,
not,
examine,
they are delaying
I
the
should be,
process.
I
my
should
lord.
be allowed to participate in the
What do you
proceeding
want
to
to
my
prove by this
satisfaction also, my lord.
document? It is said that, my lord, your lordship, which was rejected on the day of its filing on the ground of lack of merit, as because there is no doubt as to the
But
authenticity of the
you are
document.
doubting so many people, are declaring so many people.
My lord, what of
Ah.
these kind of statements, I strongly object this. They are giving back statements everywhere.
And
The
you
court-
are also
the
making
tribunal
false
is-
cases
tribunal is-
against the people.
tribunal is-
Unnecessarily are harassing the citizen of
This is
India.
not the court, my lord. This is not the, my lord.
Don't make omnibus state.
Yes,
My lord.
these kind of
If
statements
you
should not come, my lord.
If you come to that conclusion,
Hmm.
then you need to put it before us.
Yes,
Don't make these statements.
My lord,
this order is
my lord.
clearly said, my
Your
lord.
submissions, the facts of.
My lord.
No, but then Mr. Paye,
No, that is in a
what is
different.
the harm in they trying to?
My lord, had it been, my lord, if it is allowed, my lord, if it is doubted, then there was a question of calling the witness.
No, it's not a question of doubt. Burden is on them.
Yes,
It's for them to decide which document they want to prove in what manner.
my lord, these documents, whom they want to call, my lord, they want to call the OP present representation, learned counsel, I have produced that praying for issuance of summons to EO. That is the election officer, my lord. Election officer election officer will have to come to prove the voter list of 1966, 70, 85, 89, 97, 2005, 2000, 2016. My lord, the court or tribunal itself said there is no doubt as to authenticity of these documents. So what needs to prove? Tribunal is accepting these documents.
So then then we can accept your submission and remand the matter, holding that the opinion of the tribunal
My lord,
is that they are not disputing the voters list.
they are not, my lord, they are not disputing the authenticity of these documents.
Matter is still under
Yes.
consideration. An observation by us this way or that way
Yes,
may have an effect in the final outcome of the opinion.
definitely, my lord.
But if the petitioner wants to call some witness, so, or it is up to them to call a witness for whatever purpose it may be.
Definitely, my lord. I accept, my lord. I have accept. But one more thing, your lordship may have to see. My lord, if instead of, if your lordship call for the records, instead of if your lordship give me one chance, my lord, how long?
We are calling for the.
Yes, my lord, if record is called, my lord, the process will be delayed once against, my lord.
No. Then if you submit, we record your submission and make it clear that in view of the observation of the tribunal, these documents be considered but ought not to be rejected on the ground of.
Authenticity. Yeah, that is, my lord, they have
But
yes.
the difficulty is, whatever we say in terms of precedent,
Yes.
and
Then-
more particularly in a matter which is pending before the tribunal.
Then your lordship may remand this matter directly to call and because unnecessarily calling for the record, again sending back, my lord.
See, if you come to page number 54. Page 54. Page of serial number 7. You see the observation of the same tribunal, of course, in a different matter.
Yes.
So it is this apprehension that they are expressing on the basis of which they file the application. They're expressing
This,
that
this is a different matter, my lord.
different matter.
Yes, because in some documents, my lord, if it is filed in the if it is not certified copy, it may not be accepted.
That's what we are saying. If you say that this is the final decision of the opinion of the tribunal, then these documents are accepted in evidence. Then
Yes.
we can prove this matter. But is it so? Will it be proper for us to close this matter by recording a finding that the tribunal has already indicated that there is no doubt as to the authenticity? We are foreclosing the tribunal to look into the veracity of these documents if required.
Then give a short that, my lord, let me bring the records, my lord.
You want to bring the records?
Yes, my lord, I will bring the records because it's court, the case is pending there, my lord.
Very good.
My lord, my second grievance is the tribunal has closed the evidence, my lord. I am to prove.
We'll examine. it.
My lord,
Let us see.
my
The-
lord. My
We
lord.
have seen that, that is the
Well-
reason the.
Mhm.
Present petition is directed against 06/09/2024. Past date. Case number BPT 11 FD 1206 of 2017. Passed by the Foreigners Tribunal, Assam, Borpeta 11. So. The tribunal by said order directed the governor, respect page 59. Order dated 6/9/2020. It is submitted by the learned counsel to commissioner that the rejection of the prayer of the petitioner to approve the voters list for the years 1966, 1970, 1985, 89, 97, 2005, 2010, and 2016, which were produced before the tribunal as exhibits. Was not called for, and the application and the petition filed by the petitioner seeking a a direction to the election officer of the district of Borbeta / North Salmara Web for issuance of an authentication report ought not to have been rejected at this stage. Learned counsel to the petitioner referring to similar orders passed by the same that has referred to an order dated 3/10/2023 passed by the same tribunal. As in a reference connection with some other proceeding, and the copy of the order is enclosed with present execution in section 12. So, learned counsel expresses, learned counsel to the petitioner expresses the apprehension that in the same period, the voters list which were presented by that proceeding as exhibits before the tribunal was rejected on the ground that those voters list not be verified from the government portal or nor the same proceeding had taken any steps to prove the documents by alternative submitted that since in similar matters voters list presented as exhibits by the proceedings were rejected in the absence of failure of the proceeding, authenticity of the same the application. When did you file the application?
My lord, my application,
Dated
my lord, on
12/8.
12/8.
Filed by the petitioner or not to have been rejected by the appeal order. So he therefore submits that the appeal order be set aside and the matter be directed, and matter be remanded by the tribunal to redecide the same afresh thereafter. This clarifying, the counsel appearing for the department strongly objects the submissions made by the counsel. He submits that in the order included itself, tribunal has returned a finding that the petition dated 12/8/2024 filed with the petition was rejected on the ground of lack of merit, as because there is no doubt as to the authenticity of those documents, namely voters list 66 2016 in all the years. So, he therefore submits that this is a frivolous petition filed with the sole purpose of resorting to dilatory tactics. Therefore, the same should be dismissed. And the threshold. Upon consideration of the submissions made by the parties before proceeding further in the matter, this court would like to call for the tribunal reports. Let the reports. Oh, you are getting the records.
Yes. By
When you say submit the petition should be dismissed, Mr. Pine submits that he would like to Mr. Payet submits that he would like to call for the reports. He'd like to produce the relevant case reports before the tribunal. When can you do it?
any date as your lordship deems fit, madam.
You give us your dates.
Immediately after vacation, then.
After vacation.
Yes, before, otherwise,
Through registry.
on third, otherwise. On third,
If it is after
after vacation, then register.
then
On,
we'll directly register it, get it.
on third, my lord, then.
Submits that, for the relevant courts.
What is the last code?
Get it from the registry.
I think it is better we directly register it.
Then, my lord, your lordship may direct the registry after vacation, my lord, immediately.
Strike the note, register it, give the reports. Comparison of the report. And the matter be listed immediately after the vacation and the vacation. Matter be listed on 23rd. Petitioner counsel will serve copies of the writ petition to all the respective councils for the respondent, if not already done.
Right. Right. Develop.
Item number 8. Item number 8.
Yes.
Order is at page number 125. Page number 125 is down.
120.
125, my lord.
Yes.
And the opinion, reason and conclusion is from 128.
Which is the link document?
The petitioner, along with my lord, Gram Panchayat certificate and Gavra certificate, exhibited one documents of land documents wherein the petitioner was inherited land from her father, my lord. It is at page number 91, my lord. 91 on the remark column, it is written, my lord. It's Assamese version, may I read, my lord?
What is your name?
In the third column, the name of the petitioner is there, my lord, Asia Khatun. With serial number 30, my lord. Dr. Zoinuddin,
Which page?
page 91, my lord.
So was the voter list of your father?
Uh, Page number, my lord. '59, my lord. It's a type copy on 60 is the vernacular one, my lord. Zainuddin. It's 1965 voter list, my lord. And thereafter, page number 66, it is 70 voter list, my lord.
Then,
These two voter lists were exhibited by the petitioners, my lord. And thereafter, although I have annexed some voter list which are not exhibited, my lord.
those voter lists have not been exhibited.
No, these two one were exhibited, my lord.
And thereafter,
Thereafter, my lord,
the voter list not exhibited.
No,
Only
the-
next year.
my lord.
So
But
what
that
will
were
you
not
do?
exhibited, I failed to submit, my lord. The petitioner exhibited voter list of 1965, 70, and 1993 of herself, my lord.
Along with your husband,
My lord,
not with your father.
not in his father, and for linkage of which is with her father, my lord, the brother of the petitioners exhibited a Jamabandi copy, my lord, wherein the petitioner is inherited property from her father, my lord, along with other siblings.
Who is your mother?
Sahara Khatun, my lord.
In which voter list her name called?
From 1977, my lord, which I have annexed here with my lord, it's for the name of the mother of the petitioner, my lord.
We are calling for the record. Heard. Read by the opinion dated 16/10/2019. Passed in FD case number FP6 378 of 2016 by the another paper for this tribunal 6th whereby reference made by the states and the foreigners like 1946 answered in affirmative in favor of the state and against the proceeding. So the tribunal held that proceeding failed discharge of Article Section 9 of the Foreigners Act 1946 and consequently declared her to be a foreigner. Under Section A of the Foreigners Act 1946. So thereafter, the present permission. There are people who are proceeding further in the matter. The court would like to examine the reports, so registry to the position. The tribunal records pertaining to FP case number from tribunal. Matter to be listed after 3 weeks on a date that we fixed by the registry. Prayer for interim considered the reports. Anyway, petitioner shall not be reported out of the country without leave of
Rashid, item number 20, matter may be fixed on Monday.
wait for a senior company.
Well, item 15, my lord, now new gradation list has come. So in view of that, and there are 25 posts, and his position is serial number 15. In that view of the matter, I think the matter can be disposed of. I need not argue on merit. Providing. Hello? Item number 15. Actually, diet, principle of the diet. As per the NCT post,
Department.
that education.
SCRT education.
Let it come up on Monday or the. Let it be on Monday or the.
We'll have it on Tuesday.
Monday.
It will be on Tuesday. Item number,
15.
item number 15,
Now I got the gradation list just in the morning.
and the request of the council.
Final gradation is.
Yes, provisional.
And to be listed on
But my
Sorry.
petitioner's number is at page,
first,
serial number 15.
110. Come on first.
Item 23 of the supplementary list, maybe taken up on Tuesday, my lord. Come up 3 days.
Lordship, item 20.
You talk to the court master, you fix the dates.
For the consideration of the entry order.
On the priority council for the petition. It's a pretty one to make a be adjourned. To this and list after entering to the application.
May I please, Lordship? Lordship, I beg to mention item number 20, Lordship. Status has been called for, Lordship. A status report has been not received. So
Let the matter is wait for some time. Yes.
I beg to mention
Report.
item number 11, Lordship.
Hmm.
This matter may kindly adjourn for the day. My senior ME Mandal suddenly left the court, Lordship, after vacation, Lordship.
Have we informed the other side?
No, Lordship.
You have not informed. Next matter.
Hello, Lordship.
That case also we have withdrawn on last occasion.
Mm-hmm.
The case also which we have withdrawn from this honorable court Lordship, on last occasion due to some typographical error Lordship. And it is before your Lordship only for withdrawal, and as well as the co-accused was granted bail by this honorable court, the main named accused Lordship. That order is also here. It is the case of 2015. That order Lordship will find on annexure 4, page 28.
What from you are saying is the main accused?
Lordship?
Where from you are saying that he is the main accused?
No, because he is named in the FIR, Lordship. We are not named. He is the main officer who put signature on that. The FIR says that. Type questions? We have also type copy. We have annexed type copy. That the FIR, the relevant portion starts from page 13.
Mr. Bushra,
My lord.
get this status will be either Tuesday or Thursday.
My lord. It was 2015.
So what matter?
If some protection is given, Lordship will appear, Lordship.
My lord.
Science.
Cancel report to type marana. Just get us, no,
Yes, my
any
lord.
material against the petitioner, because what we have seen here, we'll pass the order on, tell us Tuesday or Thursday. Tuesday?
Tuesday.
Okay. Mr. Munir will have it on Tuesday.
My lord.
List on 1st of October, enabling Mr. K. Boyce, additional public prosecutor. There is relevant instruction relating to such and such Friday. Because CIDPS case number such and such. With regard to the petition. Much obliged, your lord.
Obliged.
Mr. Butcher wanted the special status, status of the special case. Any idea?
My lord,
Listen,
let us before speciality. No, item number 12. Bottom.
no representation in behalf of the petitioner on call. Call for the legible scan copy of the records of special case number 05/2011 from the Court of London Special Judge, Assam. Querying in the petition of the search certificate. List of the 6.
May it please your lordship, my lord, a criminal appeal against conviction under the POCSO Act. And my lord, the 98 IA is for bail. I'm arrested since 2023-11.
Short for a report. Whether the informant has notice have been served on the informant or not. Mr. Bush, only the public prosecutor is officially able to answer it.
My lord. But that's all, my lord.
The office of the public prosecutor, Guwahati High Court, shall apprise the court on Tuesday, 1st October,
Not first of, my lord, let it be on 3rd, my lord. I'll be out of station.
3rd of October. Pertaining to service of notice on the informant response number 2 relating to this proceedings.
Can I make a small prayer, my lord? Only thing, my lord, because he is seriously ill in the jail. Can there be a medical attention to the patient?
It is submitted by Mr. Such and such, counsel appearing for the petition. That the petitioner slash accused, convicted accused, is seriously ill. Using the custody, seriously ill. Will be able the jail authority shall provide the required medical assistance to the petitioner.
Yeah, pleasure. Let, as per earlier order, your lordship, a step has to be taken, your lordship, but we have taken a step, your lordship. And my lord, the notice has been also served, your lordship, as per the consignment record of post office, your lordship. And this is our hand, your lordship, but they have not appeared for this court still now. Your Lordship. But my lord, this is a case, your lordship. I am the wife of the respondent number 1, your lordship. Actually, this allegation totally false and fabricated, your lordship. Actual fact of the case.
17922024. Placed, matter be placed before the Lodgema Court for its report pertaining to service of notice on the respondent number 1.
Yes, my lord. Respondent number 1.
Respondent number 1. Placed on 23rd October. Not 23rd October. 29th October.
But still may be granted, otherwise, my lord, I am from the Nagaon and this case has been pending at Dibigor, your lordship.
We understand, we'll do it.
I am the actually main victim, girl, your lordship. Actually,
Let the report come, we'll do then.
must have it.
Your lordship. I have
Good.
taken steps, my lord, to the respondents by registered post by general post, my lord, and
Where was the
My-
office noted at
my lord.
92024?
respondent has got notice, my lord. Received, this is the post.
You cannot say that has to be said like. Where is the office note that is notes 07092024 and 179224. Notice on the respondent number 1 was issued to the district magistrate Dorong on 17/9/2024. Prior to that, notice on the respondent number 1. Was it? Respondent number. One. Prior to that, one side, which on the respondent number 1 was issued by seventeen nine zero two four and 250924. Prior to that, notice on the respondent number 1 was issued by registered post on 16/7/2024. Same name, please for lodging of court, such and such, for its report and respondent list and such and such.
My lord, interim prayer may be considered, my lord.
On the next date. the
My lord,
interim prayer will-
my lord, your lordship will, sir.
The receipt of the report of the lodging of court.
That may be fixed, my lord.
We have fixed 29th October.
No, sir, yes.
Where is the office number 2509/2024? Await service report and respondent number 2. List on 23rd October.
So, Lordship, I have some problem on 23rd, 25th.
Oh, 25th.
Same, exactly. Same, Lordship.
Same.
Same.
25/09/2024. Okay,
Lordship, if
25th.
Lordship, there in this case, just Lordship, in this case, Lordship, forest is the party. And Lordship, at the time of filing of this case, Lordship, notice was served, Lordship, but their name is not shown in the cost list, Lordship. So my submissions, Lordship, if
Registry shall reflect the name of the standing council forest. Okay, that's one number 2. Against decided. Okay.
Lordship, both case, Lordship. Highly obliged, Lordship.
My pleasure, Lord. This I has been filed for suspension of sentence, my lord. The petitioner has been convicted for 4 months under NI Act, my lord. And imposed fine of rupees 5 lakhs. Thereafter, he filed an appeal before the session court, my lord. During pendency of the session court, my lord, he already paid rupees 1 lakh, my lord. Supposed to pay the entire amount, my lord, sometimes needs, so, my lord, sentence may be.
Service alone. Service to some responsibility. Potential. Service to follow the line item. Service to follow the session. Report for the follow.
And last one, if I can honestly next to the.
The petitioner, the applicant, while they connected revision petition. Praying for setting aside and passing of the interim order dated 12/12/2023. Passed by an additional judicial magistrate Borpeta in NI case number 127/3022. Convicting him under section 138 of the NI Act. Into undergo rigorous and within 4 months. Fine of rupees 5 lakhs. And further sentenced to simple revision for 2 months in default of the payment of the final amount. State order of the learned. Edition incision Borpeta dated 12/12/2023. Was affirmed by the learned additional session judge Borpeta. While ordered at the 23/07/2023, last in criminal appeal number 01/2024 preferred by the petition. The petitioner of such criminal evidence petition has now filed his interlocutory application praying for suspension of the default judgment and order dated 12/12/2023 caused by an excess in Borpeta in case number 127 of 2022. What did the NIH to provide them? It is seen that though petitioner made such interim prayer in his connected criminal division petition, but the court while issuing notice, the said criminal division petition on 30/08/2024 did not pass any order with regard to the prayer or interim prayer of the petitioner. From the records of the case, it is seen the steps on the respondent number 2, the complainant was taken only on 25/09/2024. No, the records of said NI case number 127 of 2022 has not yet been received by the registries that was called for by order the 30/08/2022. The connected division petition has not yet been admitted. Considering the same, let's this matter again on 24th. The prayer of the petitioner shall be considered on perusal of the records. Next, it will give. We'll see him. List accordingly.
He is a service holder, so
if wait for some time, let the records come, we'll consider your case.
As per earlier order, we have taken step to the respondent number 2, 3, and 4, my lord.
My lord, we did not receive the case copy. However, I filed to Karatnama, received information. So, my lord, the case copy or petition to maybe served to me. The council.
You have not received the petition?
Yes, my lord. But we will receive, steps we have taken, my lord.
We have already.
You are appearing for whom?
For respondent number 2, my lord.
But 3 and 4 are also the daughters of restaurant number 2.
3 and 4 are the parents of respondent number 2.
No.
3 and 4, the daughters of petitioner number 2.
Petitioner. 3 and 4, 2 and 3 and 4 of the respondent number 2.
3 and 4 is the father and
Parents of
the respondent number 2. Notice was issued to the 2, 3, and 4. Accordingly, we have taken steps to the respondent number 2, 3, and 4 as per earlier order.
মানে কোশ্চেন নাই আছে পোস্ট আমাকে তা কপি কপি নাই আমার সাথে কারণ জেরক্স ছিল Reach corona.
अपना phone number तो दीजिए।
When did you file your offer letter number?
But today we are filing.
Hmm?
Today, I have filed today, just half an hour ago.
Or MS Abuzabura, counsel appearing for the petition. And Mr. Such and such. Learned counsel who has entered appearance on behalf of the respondent number 2. Complainant. Also heard Mr. K. Vishal and additional public prosecutor appear for respondent number 1. The petitioner shall serve a copy of this criminal petition elaborated and accessible to Mr. Such and such on or before 30/09/2024, obtaining necessary acknowledgement from immediate trigger. With service reports on the respondent numbers 3 and 4. List on 6th of November.
Interim order passed earlier shall continue, my lord.
Interim order passed earlier on 28/08/2024 in favor of the petitioners shall remain in force till then.
Very good. 3rd November.
May I please, Lordship? Lordship, following the last order, we have taken a steps, Lordship. And the status report has been called for on progress.
Mr. Busher, have you obtained the status report?
My lord, it is not received, my lord.
Have you intimated? Okay. What's your good name?
Jai Islam.
J. Islam, counsel for the petitioner, Mr. K. Busher, and additional public prosecutor appearing for the state. Respondent number 1. With service, peruse the office note dated 25/09/2024. With service report on adjustment number 2. List on yeah, 6th of November. On the next day, additional public prosecutor, Mr. K. Busher, shall place the up-to-date status of sessions case number 79/2024 presently pending before the court will annex session judge for project. Has been directed earlier by the list according.
My lord, in this matter, my lord, there is what is it? This pending before the session just, my lord.
On the status report, you are supposed to do nothing else.
Nothing, my lord. The status report, my lord, from the court itself, my lord.
Your public prosecutor therein will communicate to you. That's all.
Oh.
Highly obliged.
It is anywhere. Thank you for understanding.
May I please?
I'll go to the call for the status report. Make it a call for.
Hazra, no? Hazra.
Report call for also. Where is the office note dated 25/09/2024? Await service report on respondent number 2. The registry is yet to receive the status report of sessions case number 79/2014 from the Court of Learned Session Judge for project. that was called for by order level 0909. Issue reminder for this list on. Okay, it could. Okay. I'll go to it. Register to put it.
Well, this matter is already admitted for hearing.
Where is going to come to be?
15/6/22 order on it. Matter may be fixed for hearing.
Whether the petitioner is paying monthly maintenance or not.
Yes.
Are you paying the monthly maintenance or not?
Yes, as per my information, they paid 3,000 as per dot.
Are you paying regularly or not?
Lordship,
Every month you are paying.
Lordship.
Heard Mr. H.A. Ahmed, counsel appearing for the petitioner. And Mr. S. Islam, led counsel for the.
That's number 2.
Sole respondent.
Sorry.
The registry has already received the records of FC Vindicate W case number 211/2020 from the Court of Learned Principal Judge Family Court Borpeta. By order dated 15/06/2022. This revision petition was already admitted for hearing. It is submitted by Mr. Ahmed, counsel for the petitioner, that pursuant to the order is at 15/06/2022. The petitioner is paying monthly maintenance to the sole respondent at ₹3,000. And which has been accepted by Mr. S. Islam, counsel for the sole respondent. Place this matter for hearing. On 3rd of December.
Interim may be continued. Interim order may be continued.
Until further order report, the petitioner shall continue to pay the monthly maintenance of rupees such and such as directed earlier by the court. Monthly maintenance such and such to the respondent number. This will respond is directed by the court on such and such. Yes.
Yes. Wait, is your honor, Lordship? Lordship, we have filed this petition with a prayer of modifying a setting aside of an impugn order dated 26/6/2023, which was passed by the learned trial court in Amingaon, Lordship. The order is at page 53 and extra 5, Lordship.
Order dated?
Order dated 26/6/2023. Item 400.
Page 57. My lord, in item number 3, my lord, it should be in page number 57, my lord. Thank you, in order.
Yes, 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 Lord.
Take your seats. Yes. Where is the illegal?
Lordship, the LCR case show maybe call for lordship, it's required for the.
Why LCR is required? You have called for earlier. You have not called for. Where is, have you annexed the evidence of, the full respondent? Have you annexed?
Lordship, the deposition is at annexure 3, page 44. Lordship.
Yes.
44, Lordship.
Yes.
My lord may also kindly peruse annexure 4, my lord. It's 313 statement, my lord. 313 statement of the petitioner, my lord. Starts from page 47, my lord.
You say that on the basis of the evidence of one brother, right?
Anil Das, my lord.
Anil Das. Haridas has before, Kartik Das has deposed. Right?
Kartik Das has deposed. Lordship, Kartik Chandra Das, Mr. Horidas, they have deposed.
Haridas has deposed. Kartik Das has also deposed.
Yes, Lordship. Kartik Das is deposed, Lordship.
And Haridas is the complainant.
Lordship.
Right?
Lordship.
Haridas is the complainant.
Horidas, Horidas is complaining, yes. In the same case which is pending before the trial court.
In CR case, my lord, 202, Haridas is the complainant, my lord. That is item number 3, my lord.
Yes, please make your submission. What we have seen that Horidas deposed before the court on which was considered by the CISM. He deposed on 16/09/2021. Your statement under section 313 was recorded on
19 February 2022, my lord.
and you have filed this application on this application is not what have been, you have not annexed all the affidavits and all. The application is also not.
Lordship, if Lordship may please to give us some time, Lordship, the senior counsel is out of station, Lordship, so
Who
I'm
is your senior counsel?
S. Kalita, Lordship. Lordship, if Lordship may allow us some time so that on the next day, because I'm not well aware with the facts of the case, Lordship.
You should have said, why have not said earlier?
Lordship, on the last occasion also, we had.
You have to see when the power of 311 is to be exercised. Right?
Yes, Lordship.
There are various judgments, but thing is this, you have to place before the court that why that power is needs to be exercised by the concerned magistrate or the concerned court
Yes, Lordship.
for recalling of a witness or for a court witness. Unless you can establish that. Okay. Or are from the same proceeding or different CRCs?
Same proceeding, my lord, except the case date. Yes,
CR case is common.
no, CR cases are different, my lord,
Different.
but order is common, my lord. Because, my lord, the checks were issued, my lord.
And the evidence of this Horidas and Kartikdas is common for all the three cases?
No, my lord. In item number 3, my lord,
Okay, look up.
different.
What's your good name?
Gidas, Lordship.
For the petitioners. Silo, I got order to connect the voice. And you are Mr.
MK Sharma.
Counsel for the complainant. Sorry, you are not for the complainant, you are for the respondent.
I am for the complainant respondent.
I'm for the accused petitioner, Lordship, revisionist, Lordship.
Thank you. For the petitioner, the respondent. Call for the scan legible copy of the CR case number 202 C, sitting for the Udanana complaint result, public 2017.
Always 190 is ready, side by CR case number 152.
CR case number
150.
152, 2017, Lordship, and one is CR case number 201.
152 C 2017. And CR case number 201 C over 2017. Scan legible, scan legible. Copy of records of such and such. From the Court of London, Chief Judicial Magistrate, Kamrup. I mean now. List on. Fifth of November. The interim orders passed earlier on 19/09/2023 shall remain in force till then.
Look,
Lordship,
November
interim is there, Lordship. Interim is there, Lordship.
We know that.
Yes.
Look, 5th of November for hearing.
Let it be because we can, once the record is there before us, only you have to consider 311, in what purpose it has been.
So, may I pray that matter may be fixed for hearing, my lord?
So that matter may be.
Not yet been admitted.
My
If we admit it for hearing, it will take some more time.
lord. Oblige.
Oblige.
My lord,
Yes, Mr. Basu.
in item 7, health share has not been received probably.
Just a minute. Who is appearing for the respondent number 2 in the other case?
Yes, my
Is appearing?
I'm here.
In both the cases. You find the local number.
We have filed our already reply, my lord.
Just.
Two hundred forty some section. There we see 200.
Mr. Basu, in the other case, the record hasn't been called for.
My lord, record will be necessary. We are relying upon the order of taking cognizance. And that's why, at least for perusal, my certified copy is not good enough. I have given the type copy also. In the other case also, in both the cases. But copy is handwritten, my lord, the order is handwritten. And it's not a very good copy, my lord.
What is the ground for your filing this criminal petition?
My lord.
Cognizance
I-
taken, why the cognizance?
My lord,
valid?
my lord, that's it, my lord. That's it, my lord. Non-compliance of section 204. Kindly come to page 14
Of the first case,
on the first page,
okay. 629, right? 7.
629,
Page number?
14, my lord.
Yes.
This is the ground, my lord, ground number 5. Now, my lord, come to the order. That is at page 32. My lord, law is this, my lord.
That.
Prima facie, there must be a case. And his opinion is required under section 204. It's hit by that man. In both the cases, my lord. The trial court below committed the same mistake now. And there are plethora of judgment, my lord, on that matter. Your lordship already knows, my lord, that is settled position of law. And our high court on various occasions decided that, my lord. So if prima facie case has been made against the accused is not there, it cannot be proceeded. The first case can be disposed of, my lord.
We'll have the records together because.
Yes,
they
ma'am.
already did- there is
I will.
something. But Mr. Zibetsa, counsel appearing for the petition. And Mr. N.K. Murray. Current counsel for the sole respondents. You are appearing in the other matter also,
Yes, my lord.
in both the criminal petitions. Registry has received the scan copy of the CR case number 129/2020.
In the other case, my lord.
Relating
Second
to
case, ma'am.
criminal petition number 69/2020.
Case number 2.
Call for the records of CR case number 130/2022, scan copy of the, I think it's legible scan copy here. CR case number 130/2020. From the court of Lanet Subdivisional Judicial Magistrate. Belasipara, Dhubri. Subdivision Judicial Magistrate, would indicate America, Belasipara, Dhubri. Let's both the matters again on 7th of November.
Madam, let it be shorter date, my lord.
It won't come, that's why, because it's a hearing day, it will be easier for all. Because say from next week, the registry will be busy in summer, there are then holidays, they will not send it for. So immediately, even if we. It will
All
get
right,
inside.
all right, my lord, all right.
Okay. The interim order passed earlier. In both the petitions and remain in force and the further. Okay.
In both the cases, my lord, interim order may be continued.
Lordship matter may be taken as last item. As item 25 in court number 1 and learned counsel is. in court number
Next.
1.
Maybe Lordship. Lordship, before we begin, I will pray for accommodation today. The counsel S. Bhuiya, she is under eye treatment at Hyderabad. She also given her leave of absence. My lords, if my lords considers her leave of absence today and accommodate us for just today.
Somewhere I would say. So, ma'am,
Lordship,
do one thing, you fix it after vacation. Give us a
immediate,
date.
immediate after vacation, Lordship,
Give
because
us a first week you don't.
there is no any interim order, Lordship, and I am the father-in-law in this case, Lordship, and I living in Singapore, Lordship, there is no any, domestic violence act against the Lordship, me, Lordship.
29th of October,
Lordship, kindly,
not in the first week.
yes, Lordship,
After
vacation on first week,
After vacation, not in the first week, we are fixing it on 29th Tuesday.
29.
Miss, as we are council appearing for the response number 2 is in this hold and is absent by filing a letter of absence. On the fair of the council properties list on 29th.
I want this.
Yes. Tell us, Mr.
Yes, my lord.
Sonar.
My lord, this is a 482 petition, my lord.
Yes.
I am, my lord, here challenging the, my lord, impugned order dated 2/6/2023, whereby the, my lord, cognizance has been taken by the learned magistrate, my lord, learned trial court, my lord. I am also, my lord, causing for the impugned charge sheet as well as FIR dated so. My lord, why, my lord? This is, my lord, because there is a bar under section 195 1B2 of the CRPC, my lord. Because, my lord, the FIR, my lord, in such cases, my lord, that FIR is not maintainable, my lord. My lord, the allegation is that, my lord, then the findings in the charge sheet 195, section 195, my lord.
Yes.
Section
B, I think
195,
so.
1B, then subclause 2, my lord. May I read, my lord?
Yes.
No court shall take cognizance of any offense described in section 463 or punishable under section 471, section 475, 476 of the said code when such offense is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court, my lord. So basically, my lord, why this FIR has been lodged at, my lord, Latasil by the respondent. The allegation is that, my lord, the respondent, he had lodged a FIR against me, my lord, at Dibrugarh police station. Saying, my lord, that there was a agreement between us and I did not pay the money. So for that one, my lord, I approach this honorable court, my lord, for seeking, my lord, pre-arrest bail application. In the application, my lord, I annexed a equipment lease agreement, my lord, saying, my lord, that this is the actual agreement, my lord, and there was a default on the part of the respondent. And considering all this aspect, my lord, we kindly see, my lord, that order, my lord, of bail order, my lord. May I take to the, my lord, is number. Bail application.
Bail petition starts at 57.
My lord.
Your bail petition starts.
My lord,
at
my 37 onwards, my lord. 49, my lord. My lord, order, my lord, will find it, my lord, page 33 and 34, my lord. My lord, page number 34. From the bottom, my lord, may I read from the 5th line, my lord? I have given my NCS consideration to the contention of the Law and Council of both the parties. The entire dispute arose on the basis of written lease agreement. I do not find any incriminating materials for constitution of a criminal case. So and so and so. So, my lord, basically, my lord, relying on that equipment agreement, my lord. And after hearing the parties, my lord, this honorable court was pleased to give me, my lord, pre-arrest bail application. Following which, my lord, the FIR. May I take to the, my lord, my petition where this document which is alleged to have been forged, my lord. My lord, kindly turn to page number 25, my lord. Annexure 1. Type copy is page number 24, my lord. Now, this agreement is made on 20 January 2017, my lord. It's something, my lord, I am a page number 25, my lord. My lord will find this type copy at page number 24. I will read from type copy, my lord.
Okay.
Equipment rental agreement. This deed of agreement is made on 20 day of January 2017 between Sri Manish Agarwal, here in call as the lessor, and Sri Tagung Niri, here in call as the lessee. Now, this deed of agreement is made under the following terms and conditions. This lessor has rent his phone number of Falkland, namely so and so, to the lessee on monthly basis at the rate of rupees so and so. In this regard, the lessee has paid an advance amount of so and so, so and so. The lessee shall keep and maintain the rent equipment so and so, so and so. My lord, this is the agreement, my lord, which the respondent is now alleging, my lord. This is a forged agreement, and using this agreement, I obtained the pre-bearers application. This is basically, my lord, the substance of the FIR, my lord. My lord. Then what happened, my lord? May I take, my lord, my lord, what he did is, my lord, on 3/4/2018, he lodged a FIR against me at Dibrugarh police station. My lord will find it page number 28, my
lord. Right.
In this FIR in the Dibrugarh, my lord, now he has used certain agreement, which now I am saying, my lord, that is the forged agreement. And for that, my lord, I have lodged a FIR against him at Duimuk police station, Itanagar. The case is pending now, my lord. And he was arrested for that case also, my lord. Now, my lord, my lord has seen page number 28.
Yes.
You see, this is the FIR against me at Dibrugarh police station, for which, my lord, I have been granted pre-arrest bail, my lord, from this honorable. My lord, immediately thereafter, what I did is, like, my lord, then I also lodge a FIR against him. My lord will find it page number 52. Page number 52, my lord.
Right. At Duimuk.
At Duimuk, my lord. Saying, my lord, that he has, my lord, using my name, because I have never used any letter pad or anything, my lord. Now he has used and he has forged that document, and therefore he lodged a FIR at Duimuk police station, at Dibrugarh police station, my lord. My lord, I also lodged against him, my lord. Then, my lord, before that, my lord, so far Dibrugarh police station case is concerned, my lord. Then, my lord, during investigation, police could not find out anything. Therefore, my lord, final report was submitted. But the objection was placed. Thereafter, further investigation order was passed. Thereafter, I have no idea about the status of the case, my lord, as on today, my lord. What happened? What is their status, my lord, as on today. So far, about my FIR, my lord, against the respondent is concerned, my lord. Then, my lord, kindly turn to page number, my lord, 27, my lord. This is the, my lord, one of the person who is Ashish Kumar Agarwal, my lord. Because, my lord, as per this agreement, which is alleged to be forged, my lord, as per this agreement, I issued the check amount. I issued the check amount at the direction of the respondent in the name of, my lord, this Ashish Kumar Agarwal, my lord. And this is the certificate issued by the Ashish Kumar Agarwal, my lord. And this is a part of the charge sheet, my lord, of the Duimuk police station case, my lord. My lord, may I read here, my lord?
Lordship, I would like to interrupt. There is no charge sheet in Duimuk case. There was an FR. He is misleading the court. The Duimuk case that he has registered against me ended in an FR. You filed a petition and then it was reopened.
Mr. Agarwal,
Please don't mislead the court.
we'll come back to you. Okay, just a minute. Yes, Mr. Sona.
Yes, sir.
My lord, in that regard, my lord, I will submit one more point, my lord. That case, my lord, Duimuk case was, my lord, submitted as a FR, my lord, Then, my
Yes.
lord, we file a application, protest petition. And thereafter, my lord, now this has been reopened. Case has been reopened, direction given for further investigation. Now the case is under investigation. So far, Dumu police case is concerned. I think my London respondent will accept this version, I think. This is a fact as on today, madam. I will
We
place
only
the-
contradict when you lie on the court. We don't contradict on the true facts, Mr. Sona.
Like, I'm coming to that point. I'm addressing my lord, my lord. My lord,
I'm also not addressing you.
my lord,
Mr. Agarwal, listen to, you have a chance to reply, right? You can tell us.
my lord, then during investigation, then this Manish Agarwal, Kumar Agarwal was called, my lord, in the police station during the, then he has given this certificate, my lord. This saying that, my lord, may I read, my lord? I, Ashish Kumar Agarwal, hereby declare that on request of Mr. Manish Kumar Agarwal, I had deposited check bearing number so and so of Tagung Miri in my HDFC bank account, which was actually handed over to Mr. Manish Agarwal, the detail of which are as followed, my lord. There is a, my lord, from these amounts are debited from my bank account also, my lord. The above amount has been disbursed from my account as per instruction of Mr. Manish Kumar Agarwal, detail of which are as follow, my lord. These are the amounts, my lord. This amount was paid, my lord, as per this equipment rental agreement, my lord. Because this, as per this equipment rental agreement, my lord will see, my lord, at para 2, clause 2, it says that the lessee has paid an advance amount of rupees 14 lakhs, my lord. Following which only this amount was paid, my lord. And I think there is no even disputed, my lord, this thing. During the investigation, my lord, when this FR was filed, my lord, this certificate was enclosed by the police. And then, my lord, I will, my lord, then, my lord, 161 statement of the accused person, my lord. He was examined, page number 53 to 56, my lord.
Yes.
Is the type copy, my lord. The statement of the respondent, my lord, 161 statement, during his examination is, my lord, Dumu police case, my lord.
Please.
My lord, I will read, my lord. Statement of accused so-and-so Manish Agarwal. On being examined, I am to state that I have 5 numbers of L&T company's hydraulic excavator. These machines belongs to my mother, Srimati Bimla Devi Agarwal, and I am looking after her machine. In the month of January 2016, I have been approached by MS so-and-so venture that they want excavator for hire on their request. I agreed and given the vehicle machine to JKM joint venture company. Accordingly, they have taken the machine after agreement for the period of 1 year. After the expiry of the agreement, I have given 4 notes of excavator to Tagung Neri on 21/2017 on hire basis at the rate of rental charge rupees so and so per month. I have never told him that machines are actually belong to my mother. First, he misrepresented that it belongs to my mother. He has given me rupees 14 lakhs is an advance payment. Then after I have never visited to the site of Tagung Neri to see the machine, although Tagung Neri called me several times to visit there at Mariang. Then after about 1 year, I have falsely lodged FIR against Tagung Neri at Dibrugarh police station, alleging him that he had physically assaulted me, and accordingly a case was registered at Dibrugarh police station. I have also submitted a document letter paid of Tagung Neri to the Dibrugarh police station, citing falsely that the agreement was made at Dibrugarh. I admit here that I have committed wrong towards Tagung Neri, so and so and so and so. What, my lord, he did is, my lord, because, my lord, with the help of my lord, with the help, now, my lord, when question asks, my lord, why you have lodged false FIR at Dibrugarh police station? It was done on the advice of my advocate to get back the Falkland from Tagung Neri without paying repairing charge. Now he's saying, at the advice of advocate, I have lodged false case just to get back my Falkland, my lord. Where do you keep the question document? At my Calcutta office, which is now being brought to here by my brother. Now, my lord, basically what happened is, my lord.
Okay, this is 161.
161.
So nothing.
My lord, my lord. But, my lord, but so far this payment is concerned, my lord, it is so far clear, my lord. Now, why I am stressing this one, my lord? Now, my lord, after doing this thing, my lord, he filed as on today. Now, thereafter, my lord, I also lodged against him, my lord. Then now the case is pending against him. It's under investigation. So far, the question document, my lord, against whom, my lord, whether this agreement is a false or a forged, this is also the subject matter of my lord, this Duimuk police station, my lord. Because I said in the Duimuk police station, because there was an agreement, and on the basis of that agreement only, my lord, I paid amount to him, and whatever he has done, he has forged the document and filed the false case at the Dibrugarh police station. Now, my lord, what he does is, my lord, let's see the Latasil police case.
Yes,
FIR.
79.
My lord. Page number 78 and 79, my lord. My lord, this original, my lord, this starts from page 57 to 73. Initially, my lord, police refused to register the case, my lord. Then he went till commissioner, thereafter only got this case registered, my lord. May I take my page number 57, my lord? This is the FIR, my lord, type copy, my lord. I'll just read, my lord. FIR against Tagung Niri, LI so and so and so and so so and so. Sir, please find attached here with a copy of the anticipatory bail petition filed by Tagung Niri, LI Tagung Niri Talo with the Guwahati High Court at so and so. On page number so and so instance, Tagung Niri, LI as attached enclosed are erased signed by me. I would like to state here that no such agreement had ever been signed and executed by me with Tagung Niri, LI Tagung Niri Tals for leasing out excavator. I would also like to add here that the signature on page 22 of the anticipatory bailing LS to have been done by Sri Manish Garwal and Lesser are not mine, so and so. Thereafter, page number 59, Suspal Paswan claims to be witness to the forged agreement. He is also part of the criminal conspiracy, fraud, and cheating along with so and so and so. Suspal Paswan was arrested by Dibrugarh police in so and so, which is the FIR under which Tagung Niri, LI Tagung Niri has also paid anticipatory bail before this Honorable Court, High Court. It is pertinent to mention that Tagung Niri, LI Tagung Niri is the prime accused in FIR number so and so, so and so. Tagung Niri, LI had suspected this said agreement even while lodging FIR against me with Duimuk so and so, so and so. Now, my lord, some substance is only is that, my lord, I used a forged agreement to obtain the pre-arrest bail application. Now, my lord, may I take, my lord, to charge sheet, my lord? What's the findings of the policeman during the investigation? I'll straightly take page number 80 onwards. Because, my lord, ultimately, these facts are not that relevant. Ultimately, the question whether, my lord, section 195 will be attracted or not, my lord. This is the issue, my lord. Page number 80 onwards, my lord. Annexure 15, my lord.
Page 80.
Page 80, my lord.
Yes.
My lord. This is the charge sheet, my lord. The section is 468 and 471, I guess. My lord, let's see the findings, my lord. Page number 81A, my lord. May I read, my lord?
Yes.
This is important. The fact of the charge sheet is that on 10 so and so, the complainant Sri Manish Agarwal lodged a complaint informing that one Sri Tagung Niri Talo had filed an anticipatory bail petition in the Honorable Guwahati High Court in connection with Dibrugarh police case number so and so, and with the bail application, Sri Tagung Niri had submitted a forged equipment rental agreement purporting to be executed in between him and the complainant for hiring 4 numbers of Pockland excavator so and so. During the investigation, the complainant Sri Manish Agarwal and the witness had been examined in connection with the case, and their statement recorded under section 161. One photo-state copy of the equipment rental agreement. My lord, may kindly, my lord, note this particular thing. One photo-state copy of the equipment rental agreement, my lord. Original as on today, my lord, police has not even, my lord, obtained, my lord. Specimen handwriting and signature of Manish Agarwal. One photo-state copy of application by Manish Agarwal addressed to the SPL, DGP, so and so, and specimen handwriting and signature of Tagung Neri had been sent to the DFS Assam Kahlipara Guwahati for examination and furnishing of the opinion. As per the examination report, the photo-state copy of the application of Manish Agarwal addressed to the specimen handwriting and signature of are same, but there is no opinion in respect of the question document, that is one photo-state copy of the equipment rental agreement. My lord, as of my lord, this FSL, there is no such report, my lord. In this case, my lord, that whether this agreement, equipment rental agreement, which is alleged to be a forged document, whether it is a forged document or not, my lord, there is no any opinion from the FSL, my lord. Now thereafter, may I read, my lord? But during investigation, now, my lord, it is found that the question document, equipment rental agreement, had been submitted before the Honorable Guwahati High Court while applying for pre-arrest bail in connection with Dibrugarh police case number and on physical appearance. My lord, here, now the IO is saying on physical appearance, my lord. As per his physical appearance, he is giving the findings, my lord. And on physical appearance, the signature of the Manish Agarwal put in the equipment rental agreement is far from the similarity with the specimen of signature of Manish Agarwal and the signature of Manish Agarwal put in the photo-state copy of application by Manish Agarwal addressed to so-and-so. Under the circumstances, it is found that accused Sri Tagung Neri had manufactured forged equipment rental agreement purporting to be made in between himself and the complainant Manish Agarwal for hiring 4 numbers of Pockland and submitted the same in Honorable Guwahati High Court at the time of applying for pre-LS bail application in Dibrugarh so-and-so. Therefore, I beg to submit charge sheet under 468, 471 against the accused Sri Tagung Neri so-and-so below name witness will prove. But here I pause for a while. Now, so far the place of occurrence, my lord, where exactly this document was forged and when it was forged, my lord. So far, my lord, this from the, my lord, kindly turn to page number 83, my lord. Page number 83, sketch map of the place of occurrence, my lord. Page number 83, my lord. Now, A, the place of occurrence, A is saying that indicates to the complex of old building of Guwahati High Court, which is the PO as stated by the complaint. My lord, this is very important. This is very crucial for deciding this case, my lord. Now, the findings of the IO and as per the version of the, my lord, complainant is that it was the inside the complex of the court building, my lord. This forged document was, forgery was done, my lord. My lord has got that point, my lord. My lord. Now, my lord, this is basically the facts, my lord. And as on today, my lord, he has lodged against me, my lord, 1, 2, 3, 4, 5. As on today, 5 FIR against me. It's under investigation. It's going. How many filed by you against him? Against him, my lord, against him, I have filed only one is there. Okay. Now I will be filing also because Dibrugarh also he has done, and already I have instructed the client to file the FIR for again to see whether that document used in the Dibrugarh police station, my lord, because from my client is saying that that is not at all his document. He has never put signature on the document. Because what he's done, my lord, is like how to get back his 4 machines, my lord. He could not go to Arunachal. Reason being, my lord, it happens something like that. There was so many liability. So if he goes there, there would be problem. From the record also there, some other employee, his employee, they also were like retaining the machines, my lord. So it was under those situations. Of course, my lord, in this case, those may not be so much relevant, my lord, because basically here we have to see now, my lord, whether under these circumstances, let's assuming, my lord, let's assume that it was forged even in the High Court complex. This is what he's saying. Let's assume for a while. With the client came in the Guwahati High Court complex inside, it was forged. Because this was the allegation and finding of the police. And it was filed in the bail application of them. Now the issue is before this, under this circumstances, whether the bar of section 195 will come or not. That is only the question, madam. Once says that bar comes, my lord, then you don't have a right to file the private complaint. You don't have the right to pursue the matter, and the learned trial court cannot take cognizance of the matter unless, my lord, the court concerned, if finds there, my lord, this is something affecting the administrative justice, files the FIR, that is a different issue altogether. So I will be, my lord, apprising my lord on that issue, my lord. Section 195, my lord. 195, my lord, 1, subclause B, then my lord, 2, my lord. My lord has seen that one, my lord.
Yes, yes.
Now, my lord, I have gone through certain judgments of the apex court, my lord. Because, my lord, what the law is saying, my lord, is something like, suppose if you have forced some document long time before, using before the court, my lord, then, my lord, you can file the FIR, my lord. My lord, it has to be read with section 340 of the CRPC.
Yes, right. Right.
340 of the CRPC says, my lord, how the complaint has to be made. My lord. So, my lord, the settled proposition of law is like this, my lord. It's not, my lord, that suppose, my lord, a document is forged outside the court, my lord. Much, my lord, prior to, my lord, using it before the court, my lord. Then, of course, my lord.
Yes.
My lord. My lord, then the law is saying, my lord, then in such situation, there is no requirement of filing complaint by the concerned court, my lord. The private party can always file the FIR when the alleged FIR, this document is forged much before using before the court, my lord. This is the so far settled proposition. But so far, my lord, my case is concerned, my lord, this will be covered by, my lord, judgment, my lord. I'd like to place, my lord, this judgment of 1998 to
Yes, yes, Mr.
my lord, my lord, other relevant, I will just take, my lord, to one paragraph, para 12, my lord, page 4999. It would be strange thinking that any offense involving forgery of a document, if committed far outside the precincts of the court and long before its production in the court, could also be treated as one affecting administration of justice merely because that document later reached the court records, my lord. This all judgment, my lord, is dealing, why I am emphasizing section 12 is, my lord, is saying, my lord, that suppose document is, my lord, this document, the alleged forgery, my lord, if that is not committed inside the precincts of the court, my lord, if it is far outside, my lord, then this bar will not be there.
But since the place of occurrence has been shown inside the court, you are saying that there is a bar.
Yes, my lord, because judgment is on that line. If it is, my lord, outside, then it's okay, my lord. Then there cannot be bar. I would not, my lord. This is my case, my lord. And my lord has seen, my lord, the place of occurrence. It is shown that because, my lord, this judgment is saying, my lord, this judgment has dealt with that aspect and is saying that it would be strange thinking that any offense involving forgery of a document, if committed far outside the precincts of a court and long before its production in the court, in that situation, bar will not come up. But now the allegation against me is, my lord, inside the court, this was forged and used for the for obtaining bail, my lord. Then definitely, my lord, this section 195 will come into existence, and it will be a bar for taking cognizance by the learned trial court. This is basically my case, ma'am. Because this bar 195 comes into play when any offense is done within the court complex. This is what my understanding of reading of this judgment.
Anything else?
My lord, basically on this, and this judgment has been upheld in the, my lord, constitutional bench judgment also. May I place, my lord, this judgment?
So your sum and substance is that since the FIR lodged by the respondent before the Lotus Hill police station, allegedly on the basis of forgery committed inside the court.
Yes, my lord.
So the magistrate could not have taken any cognizance.
Yes, ma'am.
With regard to the charge sheet submitted by the police.
My lord.
In that particular Lotus Hill police. That is your case.
My lord. And in the charge sheet also, finding is also there.
That
It's not
the-
only my submission, findings of the prosecution is that it was inside the court. My lord, this judgment was upheld by the, my lord, constitutional bench judgment 2005, this particular 1998 judgment also, my lord.
2005 for SCC.
Yes, my lord, 2005 versus 370, my lord. With this, that is basically, my lord, my case.
Okay. Now, Mr. Agarwal, what do you have to say?
Lordship, before I start my submissions.
No, we are not on others. Thing is this, just see, has been read out with regard to the charge sheet, right? And
Lordship, Mr. Sonar has done half of my job actually. He is, should be thanked for actually bringing half of my case out here.
Okay, Mr. Agarwal, please come to the
charge sheet.
Come to
Lordship, before we go to the charge sheet, can we take your Lord's attention to page 25 and 26 of this petition also?
Sure, why not?
Lordship, it says it is a certified true copy, certified by one advocate called Mr. P. Taffo. It is never an original filed in the court.
25
and 26. This is a purported alleged agreement between me and the petitioner. What he has attached in the honorable court is a certified copy. I hope your Lordship get it here, certified to be true copy, P. Taffo, advocate.
Yes.
25 and 26, both Lordship.
Yes, that's normally what happens when you file a petition in the court. If you annex any document, it has to be attested by the concerned counsel.
Absolutely, Lordship.
Okay.
Now, it means, Lordship, that the petitioner was in custody of the original, in his own custody, and the advocate compared it with the copy that he is filing and put his signature certifying it to be a true replica of the original. Now, with the help of the court master, Lordship, I have placed one judgment before your Lordship. I hope that must have been placed before you. It is a judgment as recent as 10th of September by Honorable Justice Rishikesh Roy and R. Mahadevan. It says the same thing. If the forgery is done well outside the jurisdiction or presence of the court, 195 1B2 is not attracted, Lordship. I would invite the Lord's attention to para 4 and 5, 7 and 8. Here, Iqbal Singh Marwa and Sachidanand Singh have been defined in toto. Now, what Mr. Sonar or the learned counsel for the petitioner has submitted in 195 1B2, let me be allowed to read it out. Section 195 1B2 of the Criminal Procedure Code states that a court cannot recognize an offense if it was committed in relation to a document that was in custody of the law. Now here the court is not in custody of the original documents, Lordship.
Mr. Agarwal, you are,
The court is in the custody of a copy.
Mr. Agarwal, you are reading which paragraph? You are reading.
I am not reading the paragraph out here. I am reading the plain readings of 195 1B2, Lordship.
That's okay.
To exercise the bar under 195 1B2, three conditions have to be met, Lordship.
Definitely.
The conditions are the offense was committed in relation to a document. The second is the document was produced or given as evidence in court proceeding. And the third, the vital point is that the document was in custodial legis at that time. That means the original should have been in the custody of the court. Here we have a copy of the document. Now this recalcitrant petitioner never came up with the original for the IO to read in the FSL. When he files a certified copy, it is by implication that he has the original copy with him. Otherwise, how can he file a copy? He cannot. He never came up. Now, something I will like to put, which is very important out here, it is a golden rule that suppression and concealment of facts amounts to fraud on court and affects the administration of justice. That is what has been done by the learned petitioner for the council's petition just now. He has suppressed the fact that the crime branch of Arunachal Police has filed an FIR against the present petitioner, the OC of Doimuk, and two other police officers for filing a false case against me under 182, 120B, 403, and 406. And no opposition from the council says that I am speaking the truth. Another case has been filed by the Doimuk police for using this same forged document again because the original has never been produced by him. He is continuing using this forged document as and when required to his sweet will in the anticipatory bail petitions. And he will be continuing to commit this crime till they come into the custody of the police. Now, what more shocking I am going to reveal here is that this IO who has filed the charge sheet, he did not charge sheet the witness. Now I went to the court. The Honorable Court of SDGM 2, Kamrup Metro under complaint case CR 443 of 24 has allowed an FIR against the IO of this case. OC of Latasil and second officer of Latasil. The IO is presently additional SP, Kokrajhar crime. He is under FIR, Lordship. The petitioner has done whatever he could do to malign this court. How can he say he is innocent? In 19, the FIR was filed. In 23, the charge sheet is filed. Now, Lordship, please come to this petition. He says that I was never issued a notice or summoned to join the investigation. You have the charge sheet in front of you. You have the case diary. See whether a 41A was issued or not. Each time you come up with a new story misleading the court, it cannot be allowed. The facts have been molded in the way the council has put up. It is not at all the case where the case is. In Doimuk PS, where I was arrested, the original document between my mother and Taguneri was submitted. And the FSL has opined that the signature of Taguneri on that document is true, genuine. Why is he suppressing that fact? Does not that amount to fraud on court? How can you be so clever and cunning in misleading the court? It was your own petition 65 where you have sought reopening of Doimuk FIR where you have attached that FSL report. And Lordship, it is a great case where Supreme Court has said that when you go for further investigation, your petition should be supported by an affidavit. Even the Priyanka Srivastava judgment has been thrown into the floods. He has submitted a case without an affidavit and a further investigation was ordered. I think he is ruling something new now.
Mr. Agarwal, please listen. We are in the Lotasil police station case number. Please come to that area. We are not on. Okay.
No, he said that there is so much of dirt around there. I am saying that you are under an FIR by your own crime branch. You should be ashamed of putting all this nonsense out.
Mr. Agarwal, why should you hear all this? You go on fighting. The issue involved here is Lotasil police. Show us the Lotasil. Please show us from the Lotasil.
Lordship, before just allow me 1 minute, just 1 minute. I will like to put one very interesting aspect here. There is a cancellation of bail pending here, which is due on 21st or 22nd of next month. He has filed a reply. I just read 4 lines of that affidavit in opposition. He is the deponent there. He says that before adverting to Parawai's reply, the answering deponent begs to bring on record of this honorable court the relevant facts of the case leading to the filing of the false FIR by the answering deponent. Now you are yourself a witness against yourself. You say you have filed a false FIR against me, and that is supported by an affidavit. With regard to Dibrugarh case, which was submitted as FR, you have said on oath that you have paid 80,000 to the police officer. And this second Latasil IO is also under FIR by the SDGM. You have no defense. You are defenseless out here. You are making out a case which is against you. You say the forgery was done outside. That is the law. If it is done outside, the court will take cognizance of my FIR. Who are you to say that?
Mr.
The
Aguilar,
original is with you. Produce it.
Mr. Aguilar, we are repeating it again for you. Here is a case, a criminal petition has been filed for quashing of the proceeding of the Lotusel police station case, right? And where the court
Absolutely, Lordship.
come to that. We are not
Right,
going
sir.
anything else beyond that. We have-
Lordship, he is slinging mud on others. He should understand that he is into the dirt himself.
You are to listen to the court or not?
Yes, sir. Please.
We have asked you to submit, keep your limit here itself in the Lotusel police station case and nothing else. Please tell us any submission to be made with the case relating to Lotusel police station, the search sheet filed therein, you tell us.
Yes, Lordship. There is a lot to be said.
Please say.
Lordship,
We've already get the judgment of the Honorable Apex Court. We have looked into that. And please tell us from the FIR, the search sheet, and tell us why the cognizance was taken rightly by the learned magistrate.
Lordship, absolutely. Lordship, this Latasil FIR was lodged before the Latasil PS when anticipatory bail petition 2355 of 19
that we have seen
filed by the complainant was due.
See, basically, the FIR that you have lodged before the Lotusel police station is that while obtaining pre-arrest bail, the petitioner have annexed a particular document
Lordship,
showing that there was an agreement between you and the petition, right?
Lordship.
And you, after getting to know about that, you have submitted this FIR before the Lotusel police saying that that signature is false. The document which is placed before the court and obtaining the pre-arrest bail in that particular matter is your document. Your signature is forged.
Lordship.
And accordingly, the person who has placed that document in the court, forging your signature, the action should be taken against him.
Lordship.
And accordingly, a police case, and you say that one Seshupal something was the
witness.
Okay, that forged document.
Yeah.
Accordingly, a case was registered, right? Under section 40620 and all these things. Now, after that, the police, on completion of the investigation, submitted the search. Please come to the search sheet at page 81A. Right?
Lordship.
Read the whole page of 81A.
Lordship. The fact of the charge.
Yes, please carry on.
May I, Lordship?
Please.
The fact of the charge sheet is that on 10/10/19, the complainant Sri Manish Agarwal lodged a complaint informing that one Sri Tagumeri Talo had filed an anticipatory bail petition wide AB number 2355 of 2019 in the Honorable Guwahati High Court in connection with Dibrugarh PS case number 442 of 18 under section 406, 420, 294, 379, 506. Lordship, this will be not 379, this will be 323. Wrongly.
Okay.
And with the bail application, Sri Tagumeri had submitted a forged equipment rental agreement purporting to be executed in between him and the complainant for hiring of 4 number of Pockland excavators. During the investigation, the complainant of Sri Manish Agarwal and the witness had been examined in connection with the case and their statements recorded under section 161 CRPC. One photostat copy of equipment rental agreement, specimen handwriting and signatures of Manish Agarwal, one photostat copy of application by Manish Agarwal, addressed to the Special DGP Law and Order, Vigilance and Anti-Corruption, and specimen handwriting and signature of Sri Tauneri. Now, Lordship, here comes the case. The IO says the specimen of Tauneri has been taken. He says he was never issued a notice or summons. That amounts to fraud on court. He has submitted in the petition that he was never issued any notice ahead. Had been sent to the DFS, Assam Kailipara, Guwahati 19 for examination and furnishing of the opinion. As per the examination report, the photostat copy of application of Manish Agarwal addressed to Special DGP Law and Order, Vigilance and Anti-Corruption, and the specimen handwriting and signatures of Manish Agarwal are same. But there is no opinion in respect of the question document, that is one photostat copy of equipment rental agreement. But during investigation, it is found that the question document, that is equipment rental agreement, photostat copy, had been submitted before the Honorable Court, Guwahati High Court, while applying for pre-arrest bail in connection with Dibrugarh PS case number 442 of 18. Under section 406, 420, 294, it will be 323, 506 IPC. And on physical appearance, the signatures of the Manish Agarwal put in the equipment rental agreement is far from the similarity with the specimen of signatures of Manish Agarwal. And the signature of Manish Agarwal put in the photostat copy of application by Manish Agarwal attached to Special DGP Law and Order, Vigilance and Anti-Corruption. Next para. Under the circumstance, it is found that the accused Sri Tauneri, alias Tauneri Talo, had manufactured forged equipment rental agreement purporting to be made in between himself and the complainant, Manish Agarwal, for hiring 4 numbers of Copeland excavators and submitted the same in Honorable Guwahati High Court. At the time of applying for pre-arrest bail in connection with Dibrugarh PS case number 442 of 18 under such and such. Therefore, I beg to submit charge sheet under section 468, 471 IPC against the accused Tauneri Talo, son of Changrang Meri, resident of Doimuk, such and such. The below named witnesses will prove the case. Yes. Now, Lordship, this is the charge sheet. The case here is that
You are not audible. You are not audible. Mr. Agarwal.
Lordship. Lordship, the case here is that the petitioner says the agreement was with me. I say the agreement was with my mother. At no point of time we say that there were 2 agreements with me and with my mother. Neither he says. Either his agreement is true or my one is true. One of us is lying. Now, when he arrested me under Doimuk PS, I gave the agreement between my mother and the applicant to the police. Now, the FSL has said that the agreement between my mother and the applicant is true and the signatures are genuine. Now, the counsel has never raised a finger on the FSL report till date. Rather, he has attached that FSL in a criminal petition filed before the Honorable Itanagar bench. So, when the agreement with my mother is true, by default, this agreement is false. We do not need a rocket science to prove it. You have never challenged the FSL report. You are rather attaching it everywhere. So, if I say it was with my mother, you say it was with me. One of that is true. We never said that there were 2 agreements. So, with my mother, it is found to be true. You have attached a copy. You have never challenged the FSL. What remains in this petition? You say you were not given a chance to appear in this. The IO says that your specimen handwriting was taken. You are lying on oath. Then you come up with 195 1V2. The law is settled that if the court is in custody of the original, the court will file. If the court is not in original custody, anybody can file. Even the Karnataka High Court by Honorable Justice Suraj Govindraj has said both can file, and 2 FIRs will not amount to double jeopardy. I am not a person who can enlighten you on law. With all the things against you, you have come up with a petition saying that even if I have done forgery, if the court does not say anything, I am free. I should not be taken to task. Why, sir? Why you should not be taken to task? The court is very clear, 195 1B2, custodia legis. I repeat the word. If the court is in custody of the original, the court will file. If the court is not in original's custody, the court will not file. The petitioner will file. The aggrieved party or victim will file. And that is what your submission is. You have submitted a certified true copy. The original is with you. You never cooperated. Now the court has filed an FIR against the IO, who is an additional SP. Look what fun is going on for supporting you. And Lordship, there must be something more to be said about Arunachal Police Crime Branch is after them. They are on bail again for filing false FIR against me. One Mariang PS case has amounted to a charge sheet, and again an SI has been charge sheeted for theft. You have taken everybody with you. Everybody is charge sheeted in tandem. You don't have a case. 195 1B2 is attracted only when the court is in custody of the original, as plain as that. Nothing more, nothing less. You have filed a certified true copy. Now, where is the true copy? The true original is with you. You are not producing it because tomorrow when it goes to the FSL, your lives will be uncovered. You will not be left with any defense. So you are hiding it. Doimuk police is calling you to bring up the original. You are not attending to that. Now, my best case is that when the agreement with my mother has been found to be true, you have attached the copies. Where is the scope of this not being true? This is a forged document is proved by default.
It is a forced document. That is why Lotus Hill Police Station has given.
That is it, Lordship. Now, when he asked me that the FSL report is not there, I am answering to that. You never produced the original. How can the FSL opine? Now, that may be one part. Let us come to the other part. I said the agreement is with my mother. I seek indulgence of the court if my pitch goes up because I am attending the court from far away. I seek the indulgence. Now, Lordship, look at the situation. I say the agreement was between Neri and my mother, the applicant and my mother. The FSL has found the Neri's signature or the applicant's signature to be true on that document. What remains? You say the agreement was with me, you never produced the original before the IO. Rather, you are lying here that you are never given a notice. The charge sheet says that your specimen signature was taken. Now, when you don't produce the original, the FSL can never opine. On the other hand, when FSL has given the report that my mother's agreement is true with you, where is the scope of this being true? This is by default a forged agreement. And you play tricks. In 23, you are charge sheeted. In 24, you come up with a quashing petition. If you are so humble person, go and face the trial. You are not arrested on 41 in compliance. You will come out with flying colors. I will face the consequence of filing a false FIR. Why taking the time of this honorable court for all these nitty-gritties, which is not in your favor? Now, you don't deny that you have attached a forensic report purporting my mother's signature on the agreement with Neri was true. You have never contradicted throughout my submissions. That means you accept it. You have attached it. You have never challenged that FSL. What remains in your defense? Nothing. And you are hiding this particular agreement's original copy so that when it goes to the FSL, you will be ripped apart. Everything will fall off the skeletons. You are an officer of the court. You are not meant to play fraud on court.
My lord, he's making a personal attack, my lord.
You can take any consequence of that. I will do it. I will attend to it.
My lord, he may be restricted, my lord. It's not like this, my lord.
Lordship, I stand by every word spoken here because concealment and such acts amount to playing fraud on the court and interruption in the adjudication of justice. I don't take back my words. I will reiterate again that you are playing fraud on the court by concealing facts and hiding the facts.
Anything else, Mr. Agarwal?
Lordship, there is a lot to be said. Sorry.
So
Lordship, there is a lot to be said in this petition which he has filed. He has said that he had paid a sum of 14 lakhs to some person whom I had asked for. Now, it's a simple question I asked to myself.
Agarwal, are you listening? Listen, we are on many occasions said, you said this is, we are indeed continuing to Lotus Hill PS case number 326/2019 and nothing else, right? This is
yes, sir.
A forged document placed before the court and the charge sheet submitted by the police station, Lotus Hill police after investigation of the case. Right?
Lordship.
He has approached this course under 82. The thing is this, whether
the court shall exercise the power under 482 or not. That is to that extent you have submitted that why it should not be considered. You have placed the judgment of the Honorable Apex Court and you have said so, right?
Lordship, I will also like to appraise the court that in Sakiri Vasu, Honorable Supreme Court has said that least interference should be from the side of the High Court in trial court proceedings. And that judgment should also be taken note of. Now, when I say, now,
Yes,
Lordship,
so we know that Justice Kajju's judgment, right?
Lordship. And Lordship, I was just limiting myself within the four corners of this petition which he has filed. I'm not going beyond that. On Lordship, just a second, Lordship. On page 6, para 5.4, he says that he had paid me an advance of 14 lakhs. I did not ask anybody to pay. I had a bank account if you had the money to pay. You cannot bring up anything from my side.
Mr. Agarwal, we are not on that. We are only with the search sheet filed in the Lotus Hill Police Station case, the FIR filed in the Lotus Hill Police Station case, and the cognizance taken by the landed magistrate with regard to the Lotus Hill Police Station case.
Lordship, with reference to the cognizance taken, may I be allowed a few more minutes to bring it?
Yeah, do first because court have to rise. Yes.
Lordship, just 5 minutes will do. So far as the question of cognizance of offence under 471 of IPC is concerned, the position has been clearly settled by the Constitution bench of the Honorable Supreme Court in the case of Iqbal Singh Marwa and another versus Meenakshi Marwa and another, 2005 4 SCC 370, Lordship, which also finds mention in the judgment I have recently placed before your Lordship. When it may be held by the Honorable Supreme Court, wherein it was held by the Honorable Supreme Court that, in view of the discussion made above, we are of the opinion that Sachidanand Singh is also here, sir. Sachidanand Singh has been correctly decided and the view taken herein in the correct law, is the correct view. Section 195 1B to CRPC would be attracted only when the offence enumerated in the said provision has been committed with respect to a document after it has been produced or given in evidence in any court during the time when the document was in custodial legis.
Okay, please come to page number 84. Read the order, it is 02062023.
Case record is received from the learned CGM Kamrup Metro for disposal. Pursued the case record. On perusal of the case record, it appears that charge sheet was submitted against the accused, namely Taung Neri alias Taung Neri Talo, alleging commission of offence under 468, 471 IPC. Issue summons to the accused person, prepare copies of relevant documents, papers and documents to be furnished to the 29/8/23 for appearance and mark.
Procedure to be followed by magistrate while taking cognizance.
Lordship, there is no bar for taking cognizance under 468, 471 in this case because the forgery was done far outside this court. A copy or certified copy of the forged document is attached in the petition.
That's right. That's right.
As simple as that was.
The learned magistrate have perused the records, and on perusal of the records, he found that whoever it is found that the charge sheet has been filed against the accused persons. So under offence such and such, so issue summon. Right. Okay.
Right.
Thank you. Any reply, Mr.
My lord, my lord, my lord. My lord, in addition to that bar, my lord, because concern is, my lord, it's only with once it is outside, I would not have made that argument at all, because law is very clear. Now the case is from the PO, my lord, is saying that there is their case, my lord, inside the building of the court. This is what, my lord, because we'll be laying some law point on that aspect. Another issue, my lord, additional ground is, my lord. The my lord has seen the charge sheet. What the I was saying, my lord. No FSL report, my lord. Nothing. I was saying, my lord, no witness, my lord. I was saying, my lord, on the physical appearance of the document, my lord. Whether even if tomorrow, if we allow this such kind of question, whether it will be whether there is a prima facie case, we can say, my lord, there is a material. Even leaving aside 195 bar, even, my lord. Now, can we say because of the physical appearance of the IO, the entire case we build on 478 forgery, my lord, because report has to be there, some witness has to be there. But this is the case, my lord has seen how the findings has been given. No materials, only saying that on my physical appearance, I find that his signature is not like this. Manish Agarwal's signature is not like. And on this basis, my lord, whether if we proceed, this is my another ground, my lord. There is no prima facie. Apart from
Lordship, in
195
that
bar.
case, Lordship,
My
may
lord,
I be allowed a minute to clarify it? I will just clear off the cloud that he is trying to bring up. If that is your good case, why don't you bring up the original here in this court? Let the FSL report come up. Why are you hiding it? There is no reason for you to hide.
Yes, Mr. Busser, just tell us now one thing. Page 84. Come to the page 84.
My,
Once again, you read it.
my lord. Case record is received from the learned CGM Kamrup Metro for disposal. Peruse the case record. On perusal of the case record, it appears the search sheet was submitted against the accused person, namely so-and-so, alleging commission of offense under section 468, 471 IPC. Issue summons to the accused person. Prepare copies, relevant papers, documents. Now, my lord,
Cognizance to be taken on what basis? There has to be a prima facie satisfaction on the perusal of the records, right?
yes, my lord.
Is it there in that order? She has perused the record, she has perused the search sheet.
My-
Issue summon. The recent judgments of the Honorable Apex Court is very clear.
My lord.
Our High Court has already passed the nod.
My lord.
On what basis and how the procedure to be adopted by magistrate?
My lord.
Any document to be placed, taking cognizance will do, or the magistrate concerned taking cognizance have to be prima facie satisfied?
My lord.
On perusal of the search sheet, that is, read again that paragraph.
Yes, ma'am. Peruse the case record. On perusal of the case record, it appears that search sheet was submitted against the accused person, namely so-and-so, alleging commission of offense under section 468, 471.
Take cognizance, issue summon. Is it sufficient? In all search sheet cases, same thing. In the all search sheet, there will be something against the accused persons. Otherwise, it will be in the final report. Right? So search sheet under this section, issue summon. Is it amounts to having cognizance?
What is there? What is the ingredient force? Why?
You are the public prosecutor, you will say.
Here, my lord, the question is because it is the FIR is against the document which is placed before the court in a bail petition. And
Lordship, may I take a minute of yours, Lordship?
So FIR is relating to the document placed before the court, right?
My lord. So, my lord, there is an embargo under section 195.
That is there.
That is there.
That is the reason.
Yes,
he has
my lord.
filed. Okay.
Now, my lord, here, what the respondent number 2 is submitting, what I understand from his submission, he is stating that one certified copy or something is given in the, that is the bail petition. And the original.
He is not saying, he is saying that a particular agreement has been placed as a document in the, for his bail petition, pre-arrest bail application, that is certified to be true copy by particular council. That means there
that is the
exists
procedure.
original one.
That is the procedure.
That's what he said.
Yes.
And he said if that agreement would have been placed.
Yes.
Right?
Yes.
That's what he is saying, because the concerned council who filed that pre-arrest bail application, the concerned council made it that that agreement has been certified to be true. That's
certified.
It is
That is the procedure.
one.
Yes. Procedure. Now, my lord, if we see that it is a section 120, 195, 195, 1B, that is, it is under 2, because the two sections 471, 463, because cognizance is taken under 468 and 471. It is very much clear from the even the mere reading of the section. And in those cases, my lord, without taking the permission of court,
initiate some issue the process or something. Other than that, my lord, that embargo will come. Now here the FIR was filed on the basis of those documents which was placed before the honorable court. My lord. Now, rightly, wrongly, there may be that is in question whether it is right, wrong, or it is a part of investigation. Now the question is on that the procedure by which the investigation or whatever inquiry, whatever may be done, that is followed or not, my lord. That is here in the question, what I understand, my lord. And 195 is very clear in this regard, as because it is pending before a court, and that is submitted before a court, my lord, is annexed with the petition. So, my lord, if we see that part, but same time, my lord, the another thing is that if it is not the original one, and if it is not within the court proceeding, the document is used, and for that other document.
That is why the FIR has been lodged as a false document.
Yes, my lord. And for that reason, my lord, because my lord, today I was unable to go through the LCR also that is available, my lord, because from the order dated 2/6/2023, when cognizance was taken, that is not so much clear, my lord, of what the document and what the CD they are reflecting, what sort of exhibit, mat exhibit, and other.
Lordship, may I file an affidavit bringing the entire records and the facts before your lordship?
It's not required because facts have already been placed. We are only on that extent, right? The cognizance taken or rightly taken, wrongly taken, that will have to be seen, nothing else. This is a 482 petition, right?
Lordship, humble submission is that the petitioner is not questioning the cognizance taken. He is questioning the lodging of the FIR under 195(1)(b)(2), the bar under 195(1)(b)(2). His case is not the cognizance.
Okay. But once it comes to the notice of the court, then what should be done?
Lordship, the law is very settled. If the original is not in the court, there is no embargo. As clean as that.
Okay.
And my lord, he has projected as if something, he is only the saint, all are the sinner.
Mr. Sonar, let him argue.
You are the last person to make such a personal comment. I put you on notice, Mr. Sonar. You don't have any right to do all this.
Mr. Agarwal, if you go on like this, we'll switch off the connection.
Lordship, he should not be allowed to make a personal comment on me.
Don't you come here and argue. You are sitting somewhere.
Let it be fixed the next day, Lordship. I will be there.
This is not the way.
Kindly fix the next day, Lordship.
This is not
Fine,
the
Lordship. I seek indulgence and I pray for a next date, Lordship.
I've heard you, sir.
I will come and bring up the entire facts before you.
Heard Mr. Arsunar, counsel appearing for the petitioner. And Mr. K. Boysalani, additional public prosecutor, Assam, for the state respondent number 1. Also heard Mr. M. K. Agarwal, respondent number 2, in person, through video conference. Order reserved. Yes, what happened?
Deeply obliged.
May please, Lord. My lord, this is a 482 petition, my lord, challenging an order of attachment under the Assam Cattle Preservation Act.
Can we have it another day?
My lord,
we'll have it some other day. You're going through the records,
my lord.
After completion.
Yes, my lord.
Any day after vacation, my lord.
You are agreeing with that attachment order?
Yes. Attachment of certain immovable properties, man.
Just show us that order.
My lord, actually, what had happened was that the IO did not pass any order.
we had to move an application before the learned jurisdictional magistrate. A report was called for from the IO. IO submitted two reports wherein he has admitted that he had attached the properties. That is there, madam.
But no order as such.
Order he did not pass. He should have passed an order. He did not pass any order. And neither the most important thing is that, my lord, he ought to have issued notice.
My lord, that is,
At page number 28, my lord, he has given a list of all the properties which he has attached.
এই নতুন কেটেল প্রিজার্ভেশন এখন আইছিলেন তাতে এখন Take your seats. Where is the order of the magistrate?
Yes, ma'am.
9th of February.
Yes, page number 26.
That is 9/11.
9/11/2022.
Thereafter order is, my lord, page number 32, 15/12/2020.
Mr. Busso,
My lord,
admittedly notice was served before, because the report of the IO is very clear, and I was aware that the person was in judicial custody.
yes, my lord, 15/12/2022.
So in that circumstances, whether notice amounts to be served,
That is the only issue involvement.
it's an admitted position. And without doing it, can you go for it? Attachment of property?
And my lord, the proviso to this provision, my lord, it specifically casts a burden upon the person whose property has been attached to discharge that his property has not been acquired through illegal means. So if we do not get any notice, we cannot participate in, we cannot show that these properties were indeed not acquired from
That
illegal
is why
sale.
the order of attachment will be bad because of that only.
Yes.
No.
Yeah.
Okay. You are Mr.
Yes, that's right.
Okay, sir. 22nd, 24th given paper. is another no. Not tonight. 24th.
Man.